The day that I moved in with Mr. Galante, he grabbed my rear end as I went up his stairs, would not allow me to go down the stairs unless I kissed him.
Sexual harassment or not?
Somebody physically touched her in a sexual way, and she chose to stay there.
I had no other choice.
Baloney.
Baloney.
Baloney. I don't want to tell you what else is baloney.
Yes, it is.
What kind of property is this?
It's a home, Your Honor.
And how long has she been living in your home?
Since September of '89. I mean, '98, I'm sorry.
Okay. And according to your complaint, she has failed to pay rent and owes you for utilities. Is that
Right,
correct?
exactly.
Even though she's still living there.
Right.
She is counterclaiming for some nonsense about pain and suffering and potential moving costs. When did she stop paying you rent, sir?
In the middle of February, she paid me half of February's rent.
February of '98?
'99.
So how much does she owe you for February?
$200.
And?
Rent for March.
She has not paid March.
Exactly.
So that's another $400.
Right.
Now what about the utilities?
She paid me for September and part of October, and $100 in either January or February.
What was the lease agreement?
50% of all the utilities and her long-distance phone calls.
Okay. And in total, what does she owe you for the utilities and for her long-distance phone calls?
$799 and 97 cents, Your Honor.
Okay. And did you begin proceedings to have her evicted?
Yes, ma'am.
When she paid you, did she pay you by check or cash or money order?
By cash.
Okay. Did you give her a receipt each time?
Yes, I did, Your Honor.
Okay. And what about the utilities? When she paid you the utilities, did you give her a receipt?
Yes, I did.
Okay. You have any copies of those receipts?
Your Honor, when I prepared for this case, my receipt book suddenly turned up missing. It was in a dresser drawer, and the defendant had full run of the house while I was at work because she's unemployed at the time.
Okay. Okay. Now, you have proof that you paid him full $400 in February.
I have a receipt for $200. I spoke with Mr. Galante.
Can I see all of your receipts, please?
Absolutely.
Good. I have a receipt here, sir, that allegedly says she gave you $500 for utilities in February of '99.
I did not write one for $500, Your
Yes,
Honor.
you did, Mark.
No, he didn't.
He
you want to
did,
know
ma'am.
why? Do you want to know why he didn't?
Why?
I'm going to tell you why. Because you only paid him $200 for rent in February. You have this receipt for $500, allegedly, that you gave him for utilities, which comes at approximately the same time as your rent for February. Now, why would he not give you a receipt for the other half of February's rent when he gave you a receipt for the $200 for February, and according to you, he gave you a receipt for $500 for utilities?
Okay, can I explain two other receipts that are in there to you? I gave Mr. Galante $900 in the beginning of December. Mr. Galante argued with me that he did not receive this $900. When I returned to his home in January, he then gave me a receipt for $800 in January for that rent, and then that same day gave me also my receipt for my $400 for my January rent.
She allegedly left the money. She left me a note. I'd gone down to my mother's house, and when I returned, there was a note on my counter that said that there was $900 on the counter for rent and utilities. I looked all over the counter, through everything in my kitchen. Nowhere could I find any money at all. I had questioned her about that, and she said, well, it must be there because I left it. She, in turn, looked for it and could not find it.
Did she pay you $500 for utilities?
No, ma'am.
Yes, I did.
Mm-hmm. Where did you put this money when she gave you rent money and utility money?
Spent it. Either I'd pay my utilities that were coming up in cash, or I would spend them on things that I needed, like groceries or other things.
Well, let's get to your counterclaim for a minute. You want him to pay for your moving expenses, you want him to pay for your phone transfers, rental fees, pain and suffering, and sexual harassment.
Yes, ma'am.
I'm going to hear you.
Okay. The day that I moved in with Mr. Galante, he grabbed my rear end as I went up his stairs. The next evening, I found him with his bedroom door going up the stairs wide open in his jockey shorts, asleep. He could have closed his door. He cornered me at the top of the stairs many times, would not allow me to go down the stairs unless I kissed him. He made my bed, laid lingerie out on my bed for when I came home from work to see. He has threatened me since January to terminate my lease. But these are all threats that he was going to terminate my lease, then turning around telling me, don't worry about it, I'd like you to stay.
So what you're telling me, Ms. Thorns, is as follows. That despite the fact that from day one of you moving into this place, you felt sexually harassed, you continued to live there, and you viewed the letters months later that he was evicting you as threats. And that was despite the fact that all the time that you lived there, you were the victim of sexual harassment. Is that what you're telling me?
I am, ma'am, but I wasn't able to move. I had just received a layoff notice.
Go to a shelter. If I moved into somebody's home as a tenant, and the first day I moved there, I walked up the stairs and they grabbed my behind, unless I found them particularly attractive, I would have not unpacked my bag, stopped payment on my checks, and left.
Judge Judy continues in a moment.
This man is a stranger to you. You moved into his home, according to you, from day one. You were the victim of his sexual harassment. You stayed.
Real cases, real people. Judge Judy. Mark Galante is suing Elizabeth Thorns for rent and utilities. Elizabeth is countersuing for sexual harassment.
You know something? I don't believe you. I don't believe that a person who is articulate and appears normal, lives in a situation for September, October, November, December, January, February, and fights eviction, and then turns around and sues somebody for sexual harassment.
I didn't fight him for eviction, Your Honor. He told me to stay. He told me to go. He told me to stay. He told me to go.
What are you, a puppet? He tells you to go. He tells you to stay. You're being sexually harassed. You pack your bags and you go.
When I first moved in there, he told me that he was brought in by security to his supervisor. This was specifically.
Listen to me. I'm not interested in your nonsense.
His harassment's gone on with other people, Your Honor.
I don't care about other people. I care about you. I care about somebody who says to me that the first time she walked up the stairs in the house, somebody physically touched her in a sexual way, and she chose to stay there.
I had no other choice.
Baloney.
Baloney.
Baloney. And I want to tell you what else is baloney. Baloney is this $500 receipt for utilities because on the 13th of February, he writes you a letter, and he says in the letter, the reason he's terminating your lease is because you are delinquent in rent and because you owe $550 for utilities.
Okay, I don't.
Just a second. $550 for utilities, November 98 to February 99. And what you're telling me is after you got this,
overpaid him.
After you got this threatening letter, you paid him $500 for utilities, but you have no receipt for February, the remainder of February's rent or March rent. I don't believe it.
I didn't pay him February rent or March rent because I left his home in December. I paid rent for December. I paid all the utilities for December. Mr. Galante told me, don't worry about March. You paid for December. You weren't here.
Okay. My rationale is very simple. When you have rent receipts for every other month, but the months that are covered by his complaint, which are $600, $200 for February and $400 for March, I find that you did not pay that rent. I also find, based upon the evidence that was presented here, by way of receipts which I have examined and the letters which you have provided, that you owe him $799 for utilities. That's $1,490. Now I'm going to address your counterclaim. Any normal person, if they feel as if they are the victim of sexual harassment, who is not bound by marriage, children, family, and if they feel as if they are in an abusive relationship but have absolutely no other way out, I can understand and rationalize them staying in a home. Your situation is entirely different.
I had
This
to stay
man,
in my
this man
bedroom.
is a stranger to you. You moved into his home, according to you, from day one. You were the victim of his sexual harassment.
I was.
You stayed, and there was no reason for you to stay there. Women have a choice. You have a choice, and I gave you what your choice
To take
was.
my 7-year-old son
Go.
and stay in a shelter? I don't think so.
Absolutely. Let your 7-year-old son go with his father, go with your family, and if you don't have family, if you're telling me, madam, that not only don't you have parents, brothers, sisters, cousins, aunts, uncles that you could come to and say, I need a place to stay for a week because I made a big mistake, I don't believe you. Your counterclaim is dismissed. Judgment for the plaintiff in the amount of $14.90.
Parties are excused. You may step out.
I had nowhere else to go, and I would not put my son in a situation of danger of a shelter.
This
We
man
live
is
in
an
Seattle, Washington.
Animal.
I have a statement from her stating that she would not file anything. And again, she's gone against her word.
It's gonna go further.
This man is a nut.
Yeah.
And women
You're
should be
welcome.
afraid of him.
And now the next case.
All parties on Ratzlaff versus Sims. Step forward, please.
81-year-old Elmer Ratzlaff is suing his late son's girlfriend, 54-year-old Niona Sims, for a credit card, eviction, and funeral costs.
Mr. Ratzlaff.
Yes,
According to your complaint, sir, the defendant was your son's live-in girlfriend for 10 years.
that's right, Your Honor.
Your son passed away in August of last year, of 1998.
Yes,
Is
Your
that
Honor.
right? And at the time that he passed away, your son and the defendant were living in a small home that you owned.
Yes, that's right, Your Honor.
Your lawsuit is for 3 things. The first thing is you moved to evict her shortly after your son's death. Is that right?
Yes,
So you want the legal fees that were incurred.
yes,
You also say that she should have been responsible for the funeral expenses for your son,
yes, Your Honor.
and she did not pay. You paid.
Yes, I did.
And the third part of your lawsuit is that you say that there is a credit card, and she should pay the bill.
Yes,
Okay. So I have a couple of questions for you, sir.
yes.
Was your son working, employed at the time of his death?
My son was on a permanent disability.
Were you working at the time you were living together?
No, I also am in Social Security disability.
Why did you move to evict her so shortly after your son's death? Your son died on August 11th, according to these papers, 1998.
Yes,
And you began eviction proceedings, according to these statements, September 8th? Is that right?
I had given them an eviction notice way back in July
Why had you served them with an eviction notice in July?
because I felt that they had facilities now and means by which they could stand on their own feet.
So less than a month after your son died, you hired a lawyer to evict her.
I had to.
When did you finally vacate the premises?
Okay, it was the 14th of November, I believe, Your Honor.
What's the nature of your disability?
It's called neuromyasthenia, and it is a disease of the whole nervous system, and it leaves you totally weak, bedridden, in extreme, excruciating pain.
Judge Judy continues in a moment.
As between you and her family, seems to me, it was your responsibility to bury your son.
Closed captioning, sponsored in part by Real Cases, Real People, Judge Judy. Elmer Ratzlaff claims his late son's girlfriend, Niona Sims, owes him for a credit card, eviction, and funeral costs.
All right, now tell me about this credit card.
They came to me with this credit card problem. They said that we need some things and we don't have the means to buy them. Could we use your credit card? And I said, you can use it as long as you pay your bill. Well, they were paying on this, really, until my son passed away. After that, everything stopped.
And how much is left on that bill?
$2,844 and I think 70 cents.
Do you have a copy of that last bill?
Yes, I have, Your Honor. I got it right here, Your Honor. There's also
Did
a
you-
$500 charge in there that was given to her son by my credit card.
Did you write out a check to your son for $500? Well, that's the check. Did Mr. Raslaf Jr. also used the credit card.
Yes, he did, Your Honor.
Now, you were paying on this credit card for a long period of time.
Yes, Your Honor. Up until I was evicted because I could afford it. The rent was $200 a month.
How did you and Mr. Raslaf Jr. pay this credit card bill all along from the time you first had it? Did you pool your disability money and then pay it? Is that how you did it?
I was very careful not to abuse the card. Everything that I charged, I paid for. My payments ran at least $150 a month.
Well, even if they ran $150 a month, there were things that were constantly added to this credit card.
By him. But I did pay my bill.
Well, we don't know that. If you pooled your money together and paid this bill, then you can't say, I paid my bill, the rest of it is his. At least part of this is yours. I'm not suggesting that you are responsible for this entire bill. You understand that she's not responsible for this entire bill.
Well, Your Honor, I didn't use any of those bills.
I understand that, sir. She's not responsible for your son's bills. When you allow someone to use your credit card, sir, you always run the risk of being responsible for the bills. I can't go through these things because your son isn't here to tell me exactly what he spent and what she spent. Now, somebody's got to be responsible for Charlie's bills because you're not his wife.
Correct. And we were roommates. We were not lovers. And we had nothing between us other than a deep friendship.
$1,240 is your share of what you owe him for the credit card. Now, let's get to the funeral expenses. Did you pay the funeral expenses for your son?
Yes, Your Honor, I did because they refused to pay it.
Who refused to pay it?
Her family and Niona.
Mr. Raslaf, as between you and her family, seems to me, was your responsibility to bury your son. Now, she has no legal responsibility to pay the cost of the funeral. Neither do you. It's very sad when a parent has to bury their child, but if unfortunately that's what happens, and if the child has no funds, you as the parent have the option of either saying, listen, you can take him over to Potter's Field and I'm not paying for the burial, or bury him. But if you paid for it, you can't then come back and sue her for the money for the funeral expenses.
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Okay, Mr. Raslaf, this is not a very difficult case, sir. What did your son die from?
They finally called it hypertensive cardiac disease, and that's what they put on a death certificate.
Okay. Had he been ill, or was this sudden?
The day before he died, he was working in the yard or doing something. He seemed all right to me. That morning, he was gone.
So this is a sad thing. And right now, this lady is not in your life anymore, although she doesn't seem like a bad lady to me, quite frankly, sir.
I don't hate her.
I certainly think that she has a responsibility to pay for half of that credit card. Do you understand? I don't think she has an obligation to pay for your son's funeral. And quite frankly, Mr. Raslaf, I am not awarding you anything for the counsel fees that you paid to have her evicted, because my sense is that she would have been out of that place within a reasonable period of time after your son's death, had you just given her a little time and told her to leave. She is going to pay what I believe is a reasonable portion of the credit card bill that she and your son amassed during the time that he was alive. So I am awarding you $1,240. Thank you, that's all.
Parties are excused. You may step out.
Judge Judy continues in a moment. And on the next Judge Judy.
He evicted me because we were living in sin. And I say before God and this court, we lived together as best friends.
The biggest complaint with the relationship was their way of life to begin with. I never did approve of it.
Mrs. Shula, I'm trying to be as nice to you as possible. I find it very difficult to believe what you're telling me, Mrs. Shula. You should butt out and let them resolve their differences without you.
Meet Mrs. Schuler, the mother-in-law.
Mrs. Schuler, I just think that you're interjecting yourself into whatever's going on here, and you probably shouldn't. Quiet.
His mother, Dorothy Schuler, for her belongings after she moved out. Dorothy claims Julie owes her money.
Order, all rise.
Mrs. Schuler, this is your former husband. Are you currently in the process of getting a divorce, or are you already divorced?
Getting divorced.
And you are his mother.
Yes.
Your lawsuit alleges that when you separated and moved out of the home where you were living, and the home belonged to you, is that
Yes.
right? Certain of your property was left, both your property that you had before you were married, as well as the gifts, your wedding gifts from your side of the family. You want your property back.
Right.
Why shouldn't she have her property back?
When she was moving up, before they were married, she called and asked me to write a check for the moving van, and that she would pay me as soon as she came to town. I had no relationship with Julie other than the fact that she was with my son. 2 different occasions she said, as soon as I get to town, I will pay you. I have never been paid for it. Here is the copy of my canceled check where I paid it. I have repeatedly asked her to pay it, and she has repeatedly neglected to do so. There is also rent that was never paid. There are vet bills that were never paid.
Is that why you didn't return her property to her?
No.
Well, then, but that's...
The
Mrs.
biggest
Schuler.
reason I didn't return it to her is because she called me. She said, I'm sending a moving van up Wednesday, have my stuff ready. She had left. I took the stuff, I had to physically move it, store it in my garage. I don't know what's hers, I don't know what's his, and I see no reason why, given my age and state of health, that I should pack and go through all of this rigmarole for something that she says belongs to her.
Well, she's absolutely right. If you want your stuff moved, you have to go back and figure out what's yours and what's not yours. Why should she do that?
It's all marked in boxes. It's all labeled.
So
I
you-
packed it all myself.
So what you're telling me is you actually packed it.
I packed everything.
No, ma'am, she didn't.
Just a second. She says she packed her things. Your complaint was that why should you go through all of those things and have to pack for her? And I absolutely agreed with you, Mrs. Schuler.
Yeah.
But she says she packed everything, and everything she wants are in boxes with her name on it. Is that right?
Yep.
She did not do that. When I was told by my son...
Just a second. Mr. Schuler,
Yes,
are there boxes in your garage with your wife's name on it?
there are.
How many?
You know, I'm not real clear. Unfortunately, some of the stuff was not packed by her. That's not entirely true. I was out of town, so she packed some, and then she decided to take off and go out of town on her own thing. My parents were good enough, since I was on a business trip, to finish packing the house and move everything into the garage. All their things are integrated in the garage. Since she did pack, there's possibly some of the things are mine. I really don't know.
What do you mean possibly some of the things? Did you go through all the boxes, Mr.
I
Schuler?
haven't. That's the thing. I really haven't gone through all of this stuff because, again, I wasn't there when it was packed. I've gone down a few times and gone through some things to try and find some of my own belongings. And yeah, I do see boxes that just say just Julie, but does that mean that it's all hers? I don't necessarily agree with that. Some were wedding presents to both of us. I mean, it's really, we would need to sit down, the two of us, and go through all this.
I
you know.
absolutely agree with you. Do you understand?
Yes.
What you have to do is you have to make a trip there, sit down with your husband, not your mother-in-law, and go through the things and see if you can resolve what's yours and what's his.
Right.
That sounds pretty simple.
Right.
So what's your problem?
I don't have a problem.
Good, because I can't make a judgment as to whether the stuff that's there is yours or not. He's absolutely right. Just because you packed it doesn't mean he's prepared to say that everything in there is yours.
I gave him a list, and he agreed everything on the list was mine.
Did she give you a list?
Yeah, she faxed a copy of a list. A lot of the things I do agree with. However, where is that list? You know, a lot of things like skis, stereo equipment, odds and ends. What I don't agree with are some of the things on there, in particular wedding gifts, things we acquired together.
Now, wedding gifts. let's talk about this reasonably.
Yeah.
It seems to me when a marriage breaks up, there are lots of ways to deal with wedding gifts.
True.
Wedding gifts are given to a couple. I mean, can you make a decision now that the wedding gifts that came from her side of the family are hers, and the wedding gifts that came from your side of the family are yours?
For the most part, there's only really one thing that I completely disagree with, if I was to argue, would be the television, which actually was a wedding gift to us from her father. The question was put to me, what would I like from her father? What would we like? And it was a large television. When she left, we had bought a dog for my son together, and we had the dog and had raised it from a puppy.
You'll tell me about the dog in a second.
Sure.
That's part of the counterclaim.
Sure.
What you're telling me, Mr.
The dog
Schuler,
with the TV is the only thing, because she got the dog, I got the TV. That was the agreement, period.
No, did you agree with him that if... No, you didn't. I don't think you make an agreement for a TV for a dog.
No.
It wasn't a great agreement. It was something I was happy about.
No, it wasn't a great agreement. Listen
I'd rather
to
have
me.
the dog.
It's what he wanted.
Listen to me. The TV was bought by her father. Did you buy anything for them?
I bought, well, I should say, my husband and I bought a lot of groceries to get them started.
Things. I'm not talking about groceries. They ate the groceries.
Things. I bought some electrical kitchen appliances.
Well, those things that if you bought them, your son's going to keep.
Yeah, that's between them. I don't want any part of that.
Fine. Mr. Schuler, her father bought the TV. Buy another TV.
Fine.
Good.
Judge Judy continues in a moment.
I don't know how you get along with the other in-laws, but clearly this is not...
Wonderfully.
Well, this is not a good thing. This is not a good thing, and I have a
It
sense that your
started
son is
out
right in the
good.
middle, and he's very embarrassed by the whole thing.
Real cases, real people. Judge Judy. Julie Schuler is suing her estranged husband, Dana Schuler, and his mother, Dorothy Schuler, for her belongings.
All right, now let's get to this cross-complaint. How long were you together after you moved up from where you had been living?
6 months.
Okay. Did you call Mrs. Schuler and ask her to borrow money for a van?
Yes.
Did you pay it back?
I gave her some money for it, yes.
How much did you give her?
$150.
Did you give her $150 in check or cash?
I believe it was in cash.
Okay. Did she give you any money towards that amount?
No, ma'am.
When did you give it to her?
After I got a job when I moved up there.
Okay. What else do you claim she owes you for? Because the countersuit is yours.
Okay. There is $4,800 in back rent due.
Let's hear about the back rent. She lived there for how many months?
Okay, she moved in March. My son was already living there.
Already living in the house?
Yes, I had
How
rented
long
it
had he
to
lived
him.
in the house?
He rented it in January.
And what was the rent he was paying?
$800 a month.
Mr. Schuler, is that correct?
That's correct.
And you claim that he was paying you the $800 a month?
Not at that time, no. He had been injured on the job and wasn't
So
working.
he wasn't paying you rent?
Not at that time.
Pay attention, Mrs. Schuler. Now, she moved up there.
Yes.
She had to borrow the money to move there, you say, from you, which she agrees. She borrowed $650 from you. On the day that she moved in, or before, did you have an agreement with her about paying rent?
I would
The
say
answer
it was
is either
about
yes or no.
a week later.
What happened a week later?
I said the rent is $800 a month and the two of you are going to have to pay the rent because I can't afford to support you.
Okay, and what did she say to you?
She said, fine.
That's not a contract. That's not a contract. The contract is you have a lease. Your lease is 6 months. Your lease is month to month. You're each responsible for half the rent. You pay $400. He pays $400. What I'm getting is she moved up there to live with your son. Your son was living in your home. He wasn't paying rent. She comes up there, and you were at some point became annoyed that the rent wasn't being paid. You had a discussion with her. But you didn't enter into a rental agreement with her. And in addition to that, how many months did she live there?
Too many.
How many months did she live there, Mrs. Schuler?
About 6 months, yeah.
6 months. At $800 a month, you claim that she owes you the full rent, $4,800. That's what your countersuit says.
Okay.
Even if I believed you that you had a rental agreement with her, which I don't, why would you want to charge her for all the rent?
I don't.
Well, that's what you say here, ma'am.
The only
I'm looking
way...
at your I'm looking at your counterclaim. You say $4,800 in back rent.
Yes, of which half would be hers.
That's not what you say here. You say total back rent $4,800. Moving expenses, $800. You just told me it was $650.
No, $650. I
No.
wrote it down, $650 here.
And unpaid vet bills,
Yes.
$1,050.
Yes. She called.
So A, I find as follows, that she does owe you money for moving expenses.
May I tell you a little bit more on the rent? They had a sub-renter who paid me $200 a month. He was there 4 months. So that dropped the rent to them to $600.
Okay, so according to you now, the entire rent was $4,800, which you're attributing to her, but you didn't put in here that there was a sub-renter who paid 200 times 4 is
I had
$800.
deducted
Just a
that.
second, $800. You did not deduct that from your counterclaim. So that would bring it down to $4,000, right? And even if I believed you that you entered into an agreement with her, her share of the rent would only be half, which would only be $2,000. So I'm having some problems with you, Mrs. Schuler. I just think that you are interjecting yourself into whatever's going on here, and you probably shouldn't. Now let's talk about the vet bills. Who paid the vet bills?
I did.
The two of you had a dog?
Yes.
Yes.
All right. The dog got sick?
Yeah, had parvo.
Okay.
It was a puppy.
Okay. Who asked your mother for money?
Julie.
I did.
What did you say to her?
I asked her to split it with my father, the money for the vet bill for the dog so she doesn't die.
Okay. And how much was the total vet bill?
It's $1,100.
Okay. Show me proof that you gave her, you say $1,050 for the vet bills.
She had those receipts. I didn't, ma'am.
Are you her father?
Yes.
Step up here, sir. Did you pay for any part of these vet bills for the dog?
Yes, I did.
How much did you pay?
Julie has the figures here. I think it was about $600 or $700 all told.
They were in Southern California. I'm in Northern California, which is why I don't have any records.
I paid for the
The
dog.
records you keep with you. The records travel. Now, how do you know how much she paid?
The Visa is his, the MasterCard is hers, the check is mine, and the cash was ours together.
How much was the MasterCard? I see Visa, 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 Visa. You don't have the Visa, is that right?
Oh,
Most of this stuff is paid by Visa, madam.
all I could do was go back by the numbers and know whether it was mine or not. I won't argue with her.
Well,
It's
I
not
will
worth
tell you
it.
right now, the only MasterCard payment is $228.79, not $1,000. How many children do you have, Mrs. Schuler?
5.
Any of them married?
All 5.
Okay. I don't know how you get along with the other in-laws, but clearly this is not...
Wonderfully.
Well, this is not a good thing. This is not a
no.
good thing, and I have a
It
sense that your
started
son is
out
right in the
good.
middle, and he's very embarrassed by the whole thing.
Judge Judy continues in a moment.
Mrs. Schuler, I'm trying to be as nice to you as possible. I find it very difficult to believe what you're telling me, Mrs. Schuler. You should butt out.
Closed captioning sponsored in part by Real Cases, Real People, Judge Judy. Julie Schuler is suing her estranged husband, Dana Schuler, and his mother, Dorothy Schuler, for her belongings.
So far, I find that she owes you $500 for the moving expenses and $228.79 from the vet bills.
And there was also $1,000 charged to a credit card for an engine put in a vehicle during the time they were married.
Who asked you to do that?
He asked me just to put my card up as security, and they weren't supposed to. They were supposed to have paid for it, and instead I got stuck with it.
Sue your son. You know, if your son asks you to put something on a credit card, then you put something on a credit card.
And she did agree to pay the rent.
Mrs. Schuler, I'm trying to be as nice to you as possible. You filed a paper before me in which you say she owed you $4,800 in back rent. That's what you signed. That's what you swore to. Quiet and listen. $4,800 is the entire rent for the property for 6 months. Your son lived there. Not only did your son live there, but you had another renter that was living there that was giving you money, $200. I find it very difficult to believe what you're telling me, Mrs. Schuler. You should butt out and let them resolve their differences without you. Now, you're going to get your property back. You're going to have to make a trip. I strongly urge you not to be there when she comes up to separate whatever property there is. So I think that that's a very good idea. I have a sense, Mrs. Schuler, that the plaintiff and your son would be able to resolve this almost amicably and without a lot of stress if you weren't there. All right, on your counterclaim, I'm awarding you $1,028. You're going to get all of your property back. All right? Now, why don't you sit down? Why don't you sit down? I am calling the next case. Would you call that case, please?
Judge, this is case number 701 on the calendar in the matter of Noosa versus Schuler.
Mr. Noosa, according to your complaint, you loaned the defendant money
Yes.
prior to the marriage.
Yes.
What was the money for?
I initially loaned the defendant $3,500 as a retainer for a lawyer to get custody and visitation for his son, which he didn't have at the time.
Okay, so you asked him for money.
I did not ask him for money.
How did that happen?
My soon-to-be ex-wife asked him for the money and convinced me that it was something he could afford and something he could do, and we all went forward with it. I was kind of reluctant, to be quite honest, because of the kind of money that was involved. I mean, it's a very nice gesture, and it means a lot to me to this day. However, it's one of those things that...
Mr. Noosa, did you ever have a discussion with the defendant with regard to this $3,500?
Yes.
Tell me when that occurred and what you said to him and what he said to you.
When I agreed to loan him the money, they were sitting in my den, he and my daughter. I made it very clear this was a loan to him and had nothing to do with my daughter, and it was a loan, not a gift.
Did you say that while you were all together in the room?
Yes.
Does that sound familiar to you, Mr. Schuler?
I believe so.
Did he say to you, this is a loan to you?
He did say it was a
Fine. Good. That's it. $3,500. How much did you pay back?
$200.
Is that right?
No. The loan that's in dispute here was a subsequent loan to him. He came to me alone on January 23rd and said he had found a house because the custody order he got required a separate bedroom for his son, Alec. They found this house in Woodland Hills, and they didn't have the first and last month's rent. I once again explained to him this was a loan, not a gift. He agreed to that, and I wrote him a check on that date for $3,000. Since the initial loan was made on September 24th, I have received one payment in the form of a check for $175 in December from his mother. And this is the check for the loan that's in dispute.
Yes, sir. I'll hear you on this.
That was something, again, that Julie had asked on our behalf to be borrowed, and what Bill said to me when he gave the check over was, I am loaning this to you, not my daughter. I totally disagree with that.
Just a second.
Completely.
Did he tell you that?
He told me that, and I never agreed to it, and I don't agree with it still.
No, you did agree to it, Mr. Schuler. You did agree to it, sir, because if he says to you, I'm loaning this money directly to you, not your daughter, then you agreed to it, Mr. Schuler,
Okay.
because
If that's what it means, I agree.
Because you took the check.
Okay.
Now, if you said, I don't agree with that it's for both of us,
I just don't think I responded. I think I just took the check.
then you, by your actions,
Okay.
sir, you created a contract.
Okay.
Judge Judy will continue in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
I find right now $3,500, $3,000 is $6,500 less $175, which was paid.
Yes.
$63.25.
That's right.
Now, when you moved out of the premises, there was money returned.
Right.
How much?
$3,000.
What did you do with it?
He took $2,000, put it down in his apartment that he got with the roommate that we had at that house.
Does that sound familiar?
No, it doesn't.
How much do you think she gave you?
I honestly think it was around $800.
Could it have been $1,000?
It could have been $1,000, but it's right around that. It wasn't any
Well,
more
whatever
than that.
it is, if
Right.
it was anywhere around $1,000, sir, you're well over the limit. What Mr. Noosa is asking for in this judgment is $5,000. Clearly, you owe him that. Judgment for the plaintiff in the amount of $5,000. That's all.
Parties are excused. You may step out.
Judge Judy will continue in a moment. And on the next Judge Judy.
I'm really glad to have it over with and done and some resolve in our marriage situation. And I'm glad she's getting her stuff back, really. That's how I feel.
Our marriage wasn't concrete, wasn't solid. We had trust issues, and I didn't like living up there, and he was away.
She created problems in my family. She got in my face. She dictated to me and, in essence, threatened me. And that just turned me off.
There was a million excuses. Bonus checks, this payment, losing jobs, losing wallet, you name it, I've heard it.
Be careful who you marry.
How old are you, Valerie?
9.
Would you like to talk to me privately?
Yes. Yes.
A child's secret in the judge's chambers.
Valerie over here is very bright and lovely. I'm sure wouldn't mind my sharing with you. First of all, she loves chocolate. She had 2 pieces. What's your first name?
Christopher.
Christopher, this is your mom.
Yes.
And you're Mrs. Younts.
I am Mrs. James.
Mrs. James. This is your daughter.
Right.
2 of you are suing the defendant for back child support, your support.
Yes.
You say that you were really forced to leave your mother's home as a result of abuse.
Yes.
You went to your grandmother's home when
Yes.
you were still under the age of 18.
Mm-hmm.
How old were you when you went to your grandmother's house?
16.
16. And you've now turned 18.
Yes.
How long did you live with your grandmother?
9 months.
So it's 9 months support that you are requesting, is that
Yes.
right? You also have a claim here for some mental anguish that leads you to a figure of $5,000.
Yes.
But let's talk about the support first.
Okay.
Why did you leave your mother's home?
Because of the abuse that I was receiving.
From whom?
My mother's fiance, Larry Optigraph.
Is that him?
Yes.
Is that you?
Yes.
Larry. What kind of abuse?
Physical, mental, verbal. I get kicked, punched, hit, pinched, poked, just about anything you can think of. And
Is that why you left?
yes.
Miss Winkle, did you know about what was going on in your house?
Yes, I did, Judge.
What did you know?
I knew that Christopher had a problem with authority. We have very strict rules in our household, and he did not want to follow them.
Did you witness any corporal punishment of your son by your fiancé?
The only thing I've ever witnessed is he was grabbed by the shoulder and scolded very toughly in his face, period.
Did your son ever complain to you that he was hit by your fiancé?
He complained about it, yes.
How many times did he complain about it?
Maybe 2 that I can recall,
What did he tell you?
that he was hitting him.
And you discussed that with Larry?
Yes, I did.
Larry admit that he had hit him?
He did not say that he actually hit him. He grabbed him.
Was anything resolved with regard to your fiancé putting his hands on your son?
Yes, I asked him not to touch him.
And what did he say?
He said, that's fine.
Which must, Miss Winkle, lead you to believe that he had, in fact, put his hands on your son.
Oh, yes.
Okay. Did your son tell you that he was going to his grandmother's house?
That was a family discussion, and that was a decision that was made by all, not specifically Christopher.
Okay. Now, he came to your house, and he was there for 9 months.
Right.
Why did he leave?
Because I feel he did not want to follow the rules.
Honest. Good. Thank you. Okay. Now, were you getting child support for him from any source in the 9 months that he was living with your mother?
I have a record of the child support from the Child Support Division that I'd like you to take a look at.
No, that's...
That has the records. Yes,
So-
I was supposed to.
Not supposed to. Did you actually receive?
No.
Can I see the printout? Is that, I assume that's a printout from
Yes,
the
ma'am.
state.
It certainly is.
Let me see it.
I also have a copy.
Well, let me see yours. I'll be more than happy to look at both. So how much did you actually receive from his father?
$240 total.
Now, I want you to look at these records. You have indicated here that there are some things that are yellow lined. How much does it indicate here that your mother received for your support from your father?
Over $1,000.
You receive a certain amount of money. You're supposed to receive, what, $100?
I was supposed to receive $120.
Just for his support?
Just for his support per month.
This printout seems to indicate that for one block period, you received $676.09 paid.
Paid to me?
Yes.
I'd have to look at that, Judge.
Well, take a look at it. And then there is another figure here of $100.
After I turned 18.
See, he was
After-
not living at his grandmother's at that time.
It doesn't make any difference. This was his support.
Right.
Did you give that to him?
No.
Well, you should have. It's his support. It's not your, not your money.
Right.
This isn't alimony.
Oh, I understand that.
Child support. So.
Right. I understand that.
But-
I also tried to help him in November of last year establish the fact that he was deserving of his child support because he'd already turned 18.
Well, if you helped him and you got the money, then you should have given it to him.
I don't know why they sent it to me.
But you spent it.
Yes, I did.
Well, then you have to give that to him. So there we know
Okay,
about it.
no problem.
And what about, we'll show her this $697 that is amount received and amount paid out.
I never received that. There's also ADC owing to the state of Oregon. Because I was on welfare at certain amounts of time.
Oh, well, that makes it a little more
She's
complicated.
still on welfare status as the paper state.
So that the state is taking that money? Is that what you're telling me?
Yes.
You did not receive that $600.
No, I did not.
How much money did you receive then, in addition to this $100 of the $96 payments? You received $250?
$240.
$240 plus the 100. Okay, that brings us up to $340. Now, why do you think that I should make this $340 into $5,000?
Because of the years of abuse that I sustained by Larry Updegraff. He has a very violent nature. He has been to court many times. In fact, I have court records in my folder of an abuse against my mother, which was filed.
The reason these situations occurred are directly to Christopher Younce's behavior. Of course, parents get in arguments over children. And this little boy had a problem with authority, and he still does.
Christopher!
Yes.
There isn't a question in my mind that there was a behavior problem, and the behavior problem lasted until the time you went to your grandmother's house. I mean, she was honest with me today. She said you couldn't follow the rules and you left. So you do have a problem. Now, what started that problem, I don't know. And it could very well be that the situation in your home precipitated his acting out behavior. That's a possibility.
Yes.
You know, children are born as blank slates.
Yes, they are.
So, you know, some people say that you're pre-programmed for certain kinds of behavior, but what goes on in your house certainly has an impact on that. You know, it's half nature, half nurture. It's very foolish to allow somebody who is not related to discipline your child. It's outrageous to allow someone who is not related to that child to exercise any form of corporal punishment on that child, and that was a very bad thing, and you permitted it in your house.
Judge Judy continues in a moment.
So let me tell you this, Miss Winkle. What you're supposed to do is you're supposed to be supportive.
He refused to speak to me since Christmas.
Okay. He's angry.
Real cases, real people. Judge Judy. Christopher Younce is suing his mother for his child support. He also claims he was abused by his mother's boyfriend, Larry Updegraff.
You want to step up here? Tell me who you are.
My name is Kelly Cornick, and I'm a teen advocate in Lincoln City.
Miss Cornick, he now, I understand, lives in a program. Is he living in your program?
Yes, he is.
Is he behaving himself any better?
At first, because of the abuse that he received, and I know that I'm an abused child myself, he was confused, he was disillusioned, he was discouraged. He had dropped out of school, and it appeared to me that it had to do with his mother and Larry Updegraff using drugs and being abusive with not only Christopher, but also Christopher's brother, which he was terrified to say anything Chris at the time before he left home, which is why he felt pressured to leave home because he knew that if he left the home, his brother would receive the abuse he was receiving. He was also afraid for Valerie, okay? And
Valerie is his sister?
Valerie's his sister. She's right there.
Is he doing better now?
He is doing very well. Christopher is now back in school on a stable level. Okay, he's going to school every day.
How long has he lived in your facility?
He's been in my facility for 9 months.
And been behaving himself at least
He
for the
tried
last 6?
to misbehave, but I'm from Brooklyn, New York, Your Honor, and there is no way that he can get over on me. Okay? Okay?
I know about that.
Okay, the other part of it is, I know you do, Christopher is doing splendidly now, and as
That's
you can
good.
see, you know, and he's much happier.
Are you working as well?
Yes, I am.
Where are you working?
I work at Burger King.
Good, well, that's a start.
Yes.
How many hours a week?
I get on the average of 25 to 35.
And he does support. He does put his part in
Well, that's
for the
great.
household.
He's 18 years old, and that's okay. So let me tell you this, Ms. Winkle. What you're supposed to do is you're supposed to be supportive.
He refused to speak to me since Christmas.
Okay. He's angry.
I understand.
Step up here, sir. How long have you two been together?
9 years.
9 years. Is there any reason why 9 years and you still have a fiancé status?
None.
What do you do for a living?
I currently work at Chinook Winds Casino.
How many hours do you work?
About 35.
On the books or off?
On.
On. How long have you been working there?
Approximately 3 months.
Before that, where did you work?
I wasn't employed.
How are you supporting yourself?
Well, actually, I was self-employed. I have a computer at the house, and I do graphics and rendering. I have a degree in architecture and design.
For how many years weren't you employed with a steady income?
Approximately 2.5.
And what kind of work do you do?
I am a seasonal horseback beach guide.
Well, how does your family support itself?
Child support.
Shh. Shh. How does your family support itself? You have 2 other children at home?
Very difficultly in the winter months. It's seasonal. I've been
Well,
looking
why don't
for
you
work.
all work full time?
Because I've been looking for work.
Okay. Tell me your name.
Valerie.
Valerie, come on up here. Right here. Hi.
Hi.
You know who I am? How old are you, Valerie?
9.
9? Would you like to talk to me privately?
Yes.
Hmm?
Yes.
Okay. Why don't you come back here? Bring her back.
Watch your step. Come down here. There you go.
You hurt your mother.
I'm ashamed.
Yeah,
Family don't do this to family. You need to shut your mouth. Stop
Hey,
it.
shut up.
No.
You don't belong here.
Stop it.
All of you, stop
You need
it.
to butt out.
Stop it.
Yeah, shows how childish you are.
Have seats. Have seats.
Go ahead and sit.
See what she did to me?
What? Don't worry about it. Don't get upset.
I'm not, because I'll never speak to my mother or my son again.
He's a liar.
Never. And he's lying.
Yeah.
Lying through his teeth. Poor abused little boy. She's taking all the credit for it. I don't care. She's taking all the credit for what good he is. I hope he's proud of himself. I hope he's proud of what he's done.
Liar.
I hope you're all proud of what you've done. You're disgusting.
Judge Judy continues in a moment.
I want you to try to now erase the slate for a minute. You're the mother. It's never supposed to be too hard for you.
Closed captioning, sponsored in part by Real Cases, Real People, Judge Judy. Christopher Younts and his grandmother, Valerie James, are suing Chris's mother, Ronnie K. Winkle, for his child support.
Okay, you go sit with Larry.
Order.
Come on, baby doll.
Okay. So let's see what the things that Valerie over here, who's very bright and lovely, I'm sure wouldn't mind my sharing with you, other than first of all, she loves Godiva chocolate. She had 2 pieces. Second, she says that she's very happy in your home. She's very happy with you, sir, and she's very happy with her mother. But you don't work out of the house during the day or the night because you're home. That's why she's so happy. She's happy that you're home. So it's not a good thing to lie to a judge. Very stupid thing, sir. Second thing is, her 12-year-old brother is currently living with his father. Bottom line is, in this case, you received $340 that belongs to your son. Now, Christopher.
Yes.
Sometimes parents don't do the right thing. You don't get compensated for that. Otherwise, the courts would be flooded with those kind of lawsuits. Do you understand?
Yes, ma'am.
You also had a problem, whatever it was, whatever your authority problem was, you continued to have that when you moved in with your grandmother. I'm glad you're doing better now.
Thank you.
So I am awarding you the $340 that your mother has, took, spent, that belongs to you. It really is gratifying to me to see a young man like you who at 18 seems to be getting back on track.
Thank you.
Now, that being said, and giving you the money that I'm going to give you, it's a good idea for children not to divorce their parents permanently.
I do not want to divorce my mother.
Perfect.
I love her.
Perfect. So I gather it's been a long time since you've communicated, is that right?
Very long time.
I want you to try to now erase the slate for a minute.
Hard.
You're the mother. It's never supposed to be too hard for you. You understand?
I do.
So you've all traveled to this court a very long distance. So what I'm going to suggest that you do is that just the 2 of you today go out for lunch. And I would really like for you to be able to spend an hour with your mom without any recriminations, without any, just let her know what's going on with your life currently, how you are in school, how it is living, what's happening with your life.
Okay.
Okay? Just to start a dialogue. Is that reasonable?
Yes.
Okay? All right? Why don't you go out first, just the 2 of you?
Okay.
And I will prepare an order for $340. Just the 2 of you outside. And then I'll dismiss the rest of the case later.
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
I'm going to let them have a private hour.
Oh, certainly.
Okay?
Sure, that's
Is that
fine.
reasonable?
Is that, sure, very nice.
Okay, I would like that to happen. This young lady, Valerie, is a lovely girl, very smart, very articulate, very bright. As I said, that's usually a combination of nature and nurture. So evidently, what was not accomplished with the 2 boys in your house, for whatever reason, was clearly accomplished with this young lady who prefers to stay with you and her mother rather than going with her biological father where her brother is. There is something to be said for that, right? Sure. So sometimes you have to get the whole puzzle put into place. It's not always at one end of the spectrum or another. Sometimes there's a middle ground, right?
That's true.
Okay. So why don't you folks meet your daughter and your grandson back here in 1 hour so that you can make your plane. Thank you very much.
Thank you.
Thank you.
Parties are excused. You may step out.
Judge Judy continues in a moment. And on the next Judge Judy.
I love both of them with all my heart, and that's why I'm here.
Actually, it's probably much better that they're able to talk and get along and go to lunch.
I think it was good, and I don't want our family to break apart again.
I said, did you know there was a stop sign back there? And he said, I'm from St. Louis. We don't stop at stop signs.
Macho men.
He says, look, you're lucky I don't get my gun out of my trunk and kill you.
I do not believe that you walked up to him and said, could you please move your car? I'd like to get out. That is inconsistent with male testosterone.
Timothy Cherry claims 40-year-old railroad engineer Leroy Keller assaulted him over a parked car that blocked his. Leroy is countersuing for his 30-day job suspension and attorney fees.
Order, all rise. Yeah, this is case number 697 on the calendar in the matter of Cherry versus Keller. Parties have been sworn in, Judge. You may be seated.
You both work for the railroad, is that right?
That's correct.
Yes.
And you had this big brouhaha over parked cars. Foolish, right? Foolish. So, Mr. Cherry, why don't you start from the beginning and tell me why you believe Mr. Keller owes you all this money? $3,000 with a counterclaim for another $3,000.
On July the 18th, we have a mail contract to work for the railroad. I was up in the mail car, attending to my duties when Mr. Keller approached me. He was very upset that he couldn't get out from where I was parked.
He couldn't get out?
He couldn't get out of his
parking space because of your car?
Because of where I was parked.
Okay.
Mr. Keller approached me, and his exact words to me were, give me your keys or I'll bust your windows out and ram your car. I turned to the person I was working with at the time, and I told him, well, let me go down and move my car out of his way. As I went to get down out of the car, as soon as I touched the ground, Mr. Keller ran over to me and went to grab me in my chest. I pushed his hands off of me, and I told him not to touch me again and that I would be back. You know, I told the people I was working with I would be back. Let me go and move my car. All the way up the platform over to the garage, Mr. Keller's making shoulder contact with me. He's bumping me, telling me, who do you think you are? You have no reason to block me in, and you knew this was my car. I had no idea whose car it was. It was an area where all the employees park. If it happens to where we block each other in, we simply just come and ask to move. Once we got out to the garage, I went to open my door, to let him out. He had went over to his car. Before I could get the key good out of my door, he rushed over to me and pushed me to the side of my car. At that point, I didn't know what he was going to do. He had been to his car. He was back over there. He had pushed me for the second time. I went to my trunk. I actually ran to my trunk, opened my trunk, and removed a baseball bat. By the time I came from the rear of my car, Mr. Keller was on his way back to his car. He started revving his engine. He started moving his car forward like he was going to ram my car. And by the time I backed up enough for him to get out, he actually did make contact, but it didn't cause any damage at that point. He left the garage. I immediately picked up the phone and called 911. As I'm on the phone with the 911 operator, Mr. Keller enters the garage again from the other direction. He gets out of his car and approaches me, reaching for my phone. I have pictures of the damage that was done to my car.
Well, I thought you said there was no damage done to your car.
The damage that happened to my car was a result of him shoving me to the side. When he shoved me to the side, it was this elbow, I guess, that caused the damage.
When did he shove you to the side?
When I went to take my key out of my lock, he came rushing over to me at my car and pushed me to the side. He got inside of my car, released my emergency brake, and started pushing my car backwards.
Let me see the alleged damage to your car, sir.
Sure. Those are pictures. I have a light-colored car. It's kind of hard to see it, but I tried to take it from an angle where you could see the indentures.
It's very hard to see.
I also have an estimate, Judge, where
Let me see it.
That particular place was estimated.
Although I'm having difficulty seeing it, clearly the place where you took your car in to be repaired from where you claim that he came over and pushed you, you have a bill for $526.42. Okay, Mr. Keller.
Judge, I would like to show a diagram of the parking lot in the car incident. This shows the train as which this was where Mr. Cherry was located working on the train. I came into work that morning about 7:30 a.m. after being on duty for 14 straight hours with nothing to eat. I went from this location here to my car, which was parked here, and as you can see, Mr. Cherry's car has me pinned in between a concrete wall and two other cars.
Mm-hmm.
I walked from this location through this door to the ticket window, and I asked the ticket agent, I said, there's a Mazda 626 parked out here, and I gave him the license plate number. I said, could you make an announcement? I thought maybe there was a passenger waiting to pick up someone that had just parked there and would be there for temporary time. The ticket agent, he said, I know whose car that is. That's Mr. Cherry. He works here. I said, well, could you get a hold of him and have him move the car? I'd like to go home. He went outside to look, and he said Mr. Cherry was way down at the end of the platform here working on the train. I said, okay. I said, I'm going to call the parking lot and find out if there is a policy of double parking here.
But there are a lot of other cars that are double parked.
There was one other car double parked.
Well, I see that. So what did you do, sir?
So I went in and I talked to the security. They said it was a matter that they couldn't handle. So then they suggested calling the police and calling a tow truck. And the tow truck said that he could not tow a car unless he had permission from the police, and the car had to be parked there for 48 hours.
Okay. First you found out the car belonged to Mr. Cherry. So how long did that take? How many minutes?
Probably about 10 minutes.
Okay. And then you were still at that location when you called the tow truck?
Yes.
A tow truck. Did you have to get a number of a tow truck?
Yes, out of the yellow pages.
Okay, so you had to get the yellow pages, look up a tow truck, and call a tow truck. And about how long did that take?
Another 5 minutes.
So that's 15 minutes.
Mm-hmm.
Did you call the police?
I spoke to the dispatcher, and they said that there was nothing they could do.
That took another 10 minutes?
No.
How
just
long?
A couple minutes.
Another 5 minutes?
Yeah.
Okay. So now we're up to about 20 minutes.
Yes.
Right? And then you decided yourself to walk over to where Mr. Cherry was working.
Yes.
And how long, sir, did it take you to get from the ticket window where you were over to where Mr. Cherry was?
About 3 or 4 minutes.
Judge Judy continues in a moment.
I said, are you crazy? I said, do you realize what you're doing here? He says, look, you're lucky I don't get my gun out of my trunk and kill you.
Real cases, real people. Judge Judy. Railroad agent Timothy Cherry is suing railroad engineer Leroy Keller for assault after Timothy blocked his car.
So my first question to you is, sir, instead of calling a tow truck, which took 10 minutes, calling the police, which took another 5 minutes, 15 minutes, why didn't you just take a 3-minute walk over to where he was and say, why don't you move your car?
Mr. Cherry and I have had an interaction before.
What kind of an interaction did you have before?
One evening about 11:30 p.m., I was on my way to work and I was coming into the parking lot. There is a stop sign that's displayed because there's a bad intersection. I stopped at the stop sign. Mr. Cherry drove around me at a high rate of speed to get to his parking spot. And I said to him, I said, did you know there was a stop sign back there? And he said, I'm from St. Louis. We don't stop at stop signs.
So, what did
So
you say?
with that attitude, I figured there's no sense talking to a gentleman.
So you didn't
like
say
that.
anything to
No,
him?
I didn't.
Okay. So then you walked over there.
Yes.
And what happened when you got over to him?
When I got over to him, I said, do you own a Mazda 626? He said, yes. I said, well, you're blocking me. I said, I'd like for you to move the car.
Is that the way you said it, sir?
Yes.
You sure about that?
Yes. He said, I'll move it when I get done with my work.
Or middle.
And I said to him, I said, I have been delayed long enough. I would like to go home. I've been up for 14 hours, and I would like to go home. He said, I'll take care of it when I get done with my work. Once again, I suggested to him, I said, just give me your keys, I'll move your car for you, and I'll leave the keys at the ticket window. He threw his gloves down, and he started getting upset, cussing at me, and telling me that he wasn't going to give me his MF keys. He jumped out of this train car, and instead of climbing down the ladder, he tried to jump on top of me. And with my natural reactions of him coming out on top of me, I pushed to keep him away from me. Once he got down on the platform, then he started chest butting me around. And I told him, I said, look, I said, I don't have time for this. I want to go home. So we walked from the train back through the depot. I went through the first door in the depot from the train station, through this door and to my car. Mr. Cherry went back into the baggage room, through the employee's room, and he stayed back there another 5 minutes before he came out of there. I sat in my car waiting for him. When he finally showed up, when he come through this door and he came out here, instead of getting directly in his car and initiating the move directly, he stood by his car with his arms folded and just grinned at me. So when he came over to his car, he put his keys in his door, unlocked his door, opened up his door, got into his car, sat in his car, and looked at me again. Then he got out of his car, and he went to the trunk. So I went over to look. I looked inside the car. I noticed it was a manual shift car. I popped it in neutral, and I put my shoulder on the doorpost and give it a push back. As I was pushing the car back with my door on the doorpost, when I looked up, Mr. Cherry has a baseball bat, and he was taking a swing at me. I said, are you crazy? I said, do you realize what you're doing here? He says, look, you're lucky I don't get my gun out of my trunk and kill you. And I said, that's it.
Hey.
I said, that's it. I got in my car. By that time, I had pushed it back myself. I got in my car. As I was leaving, I looked in my rearview mirror, and yes, he did have his cell phone out, and I figured, he's calling the police. I'm going to be in trouble if I leave the location. I pick up my cell phone in my car. I call the police. The dispatcher says, yeah, we have an altercation down at the Amtrak station. I said, I think I'm involved in that. I said, would you like me to return to the location? Yes, that would probably be the best thing to do. So I returned to the location. After talking to the police, they tried to resolve the situation, and they talked to us, and they explained to us that either one of us would file charges against each other. We're going to end up in jail that day. The officer told me, he said, if you go up to him and you just shake his hand and apologize to him and say, let's forget this, we'll let it go. So I went up to him and I extended my hand, I shook my hand, and the officer said, go on, we'll take care of it. So a few days later, about 3 days later, my supervisor calls me and he asks me about this situation. The company decides to hold a formal investigation. Through the formal investigation, the facts were gathered that both of us were at fault.
Responsible.
That's correct.
And they docked you both a month's pay?
They fired us both for 30 days.
Okay. That's your cross complaint. You want the amount of money that you lost for being fired for 30 days. That's what you say here.
What I'm having a problem with is after 30 days of being disciplined, Mr. Cherry files an assault report with the police. I have to go hire an attorney to represent me in this case. It cost me $700. The prosecuting attorney dropped the case due to lack of evidence on the police report. That wasn't good enough for Mr. Cherry. Now Mr. Cherry is filing a claim against me in small claims court. I feel that if anything, I'm entitled to the lawyer's fees that I've had to pay for purely out of harassment on Mr. Cherry's part of trying to get even with me.
Judge Judy continues in a moment.
He actually had his hands firmly put on my chest, Judge, and I removed them off of
You're not a wimp, are you? You're not a wimp. You weren't injured. He overreacted.
Closed captioning, sponsored in part by Real Cases, Real People. Judge Judy. Railroad agent Timothy Cherry is suing railroad engineer Leroy Keller for assault. Leroy is countersuing for lost wages and attorney fees that resulted from the fight.
Let me tell you, I've heard your side of the story and I've heard your side of the story. Each of the stories flavored and colored a little bit to suit your own purposes. So let me tell you what I think happened. I think as far as the parking and blocking his car is concerned, Mr. Cherry, that was absolutely the wrong thing to do. You never know if you block somebody's car, whether it's for 5 minutes, 10 minutes, or an hour, or 2 hours, that say nothing. That there may be an emergency, somebody has to get their car out right away, and it's very irritating, especially when you're at some distance from where you have inconvenienced somebody. So I don't blame him for getting angry. Now, the fact that you had a history before suggests to me, Mr. Keller, that you were not as calm as you present yourself here today. I do not believe that after you spent 15 to 20 minutes trying to get even with him by having his car towed away by the police rather than walking 3 minutes over to where he was working to tell him to move his car, that you were happy with him, that you walked up to him and said, "Could you please move your car? I'd like to get out." That is inconsistent with human nature, and it's inconsistent with male testosterone. It just doesn't happen that way, Mr. Keller. So that he doesn't know what's happening, all of a sudden you come up, you've had a little tiff before, and you start screaming at him to move his car, and probably used a couple of expletives in the process. Then Mr. Cherry gets irritated, and he's going to take a walk back to help you move your car, but he's going to take his sweet time about doing it. So he's sitting in the car, burning and stewing. Now, I absolutely think that he was 100% wrong to go into your car and move it physically. Now, what I want to know from you, Mr. Cherry, is once this was all over, sir, and you had your disciplinary proceeding, and you all went through getting laid off for a month and lost wages over this nonsense, why did you file assault charges against him?
By him grabbing me in my chest, he made threats not only to me, but to my vehicle. When I got to my vehicle, Mr. Keller continued with his threats.
It's a little overreacting, Mr. Cherry.
He actually had his hands firmly put on my chest, Judge,
All right,
and I
Mr.
removed
Cherry,
them off of him.
you're not a wimp, are you? You're not a wimp. You weren't injured. He overreacted.
I have
He
sworn testimonies, Your Honor.
overreacted, sir. He overreacted. You know, I'm not going to give him an award or a testimonial dinner for his loud mouth, for his bad attitude, for doing the wrong thing, I think, judgment-wise, about your car. But there comes a point where you have to put a period and say, all right, this is enough. We both suffered from this incident. It was the wrong thing.
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Mr. Keller, I believe, sir, that you overreacted to this situation. You got good and mad. I can imagine that. You've seen people in a parking lot waiting to get their car out for 3 minutes, and they get crazy if they want to get out of a parking spot and somebody is blocking them. So, Mr. Cherry, I am giving you the money to fix your car. I think that you both got hot under the collar. Both of you. However, you had out of pocket that you can establish to me to fix your car, and I assume that you're fixing your car, sir? $526. As far as your counterclaim is concerned, Mr. Keller, I believe that in this instance, if I were to indicate that one person was the aggressor, in this case, it would be you. He may have known how to push your buttons, but once your button is pushed, that's your responsibility. And you did certain things that I could tell that somebody who was only very, very angry would do. Take control over somebody else's vehicle because they're not moving fast enough to push it away manually is something that somebody would only do if their testosterone level was up to their eyes. So judgment for the plaintiff in the amount of $526. The counterclaim is dismissed. That's all.
Parties are excused. You may step out.
Judge Judy continues in a moment. And on the next Judge Judy.
I might have got upset, but my natural instinct wasn't to go to the trunk and pull a baseball bat.
I had every right to protect and defend myself after he entered my car. That was the second time he had assaulted me. Maybe I shouldn't have hesitated to protect myself.
I had no due process of law.
Judges don't necessarily hear litigants individually when they're represented by counsel. So if you don't like what the judge did, file a complaint. They'll take your complaint and they'll throw it in the garbage.
Justice for all.
You had 2 lawyers. 2.
I was not satisfied.
I'll write a letter to dear. This is a suit against a former client of yours for non-payment of a legal fee that had been part of a retainer agreement. Is that right?
That's correct, yes.
Can I see the retainer agreement, please?
It's a retainer with the signature.
All right, so you signed this retainer agreement?
Yes, ma'am.
And for what period of time did you represent the defendant?
I represented him from March 10th of '98 was our first meeting, and on August 7th, I told him I would not represent him anymore.
What kind of proceeding was this?
It was a commercial eviction. He's the owner of property. There's a bar on the premises, and he was trying to evict the tenant.
Why did you tell him that you would no longer represent him?
Mr. Sudluka was very difficult to represent. The first action we brought, when he came to my office, he already had an action underway, and he had gone to court and said that no rent had been paid, when in fact the rent had been paid to his lawyer prior to the court date.
So he had a prior lawyer?
Yes.
Is that correct, sir?
Yes, ma'am.
Go ahead.
After that, I served a notice. I reviewed his documents regarding the lease and the documents that he gave me, and I served a notice on his tenant, noting all the violations of the terms of the lease. And after 20 days, we were to bring an eviction action. By the time we got to court, he had accepted rent, which after you terminate a tenancy, accepting rent begins a new tenancy. So again, we had to go and apologize to the judge and say that we could not go forward with the proceeding.
Did you explain to him that he couldn't accept rent?
I explained to him when he told me he had received an accepted rent, but he didn't ask me at the time he received it what he should do. Instead, he asked a friend of his, and his friend gave him the advice to accept the rent.
Now, when did you find out that he had had a prior lawyer who accepted rent for him?
When he came into my office on March 10th.
How many lawyers have you had in the last 2 years?
Ms. Taylor and my first lawyer.
Are you telling me that in the last 2 years, with regards to any action that you have had on this property, you only had 2 lawyers?
That's correct.
All right, when did you buy this property?
I sold it in August of '94.
You sold it to whom?
To my tenants.
You sold it in 1994. What were you suing them for rent for in '98?
They breached the contract, and I wanted to evict them. And I actually got an eviction granted on March 4th. The judge says, eviction granted. Then they came up with a show cause order for me. Well, I had all the goods on them. I said, let's go. Well, the second time around, I said, well, maybe I ought to take a lawyer on and go and see the judge the second time around, because all I got is a formality here. On March 16th, after confiding in Ms. Taylor, we went to court. And we stood there like we are right now. I'm in a situation with all this evidence in front of me. My tenant's landlord and Ms. Taylor walk up to the judge. They did a little bit of whispering, et cetera, et cetera, et cetera. And then she walked back out of me and says, we have to leave now. This confused me a lot, because I just wanted to be heard and have the judge decide what the problem.
Had you accepted rent just prior to your going into court on that occasion with Ms. Taylor?
No.
Are you telling me, sir, that from the time you went into Ms. Taylor's office, when you first retained her, to the time you appeared before the judge that you've just described to me, you accepted no rent from the tenant?
No, but
Who did?
I did on March 4th, not on March 16th.
No, listen to me carefully.
Yes.
So the answer to my question is, on March 4th, you accepted rent from your tenant.
Correct.
Just listen.
Yes.
And on March 16th, you went to court with Ms. Taylor. Is that right?
That is correct.
When you accepted the rent on March 4th from your tenant, Did you consult Miss Taylor prior to you accepting the rent?
I didn't know her then.
Your Honor, he did have another attorney at that time.
Did you consult your other attorney?
No, because he didn't. He wrote me a letter that said that he was dropping my case after not taking care of the business at hand.
Just a second.
Okay.
Did you, prior to March 16th, notify Miss Taylor that you had accepted rent?
Yes.
When?
When I saw her. I don't remember what date we sat down and talked, but I did tell her this.
Ms. Taylor, did he ever tell you prior to you going to court that he accepted rent?
He told me after he'd already gone in front of the judge on his own and asked for an eviction based on non-payment, and we went in on the 16th to sort of make reparations and apologize to the judge.
That you could not go forward?
That's correct.
You owe her money. Period. End of discussion.
Well, that might
You
be
owe her
so, Your
money.
Honor. But that might be so. But there still is the fact that I was breached 6 different times, and all I wanted to do is have the judge look at the situation as it existed and cast a judgment on the contract that I had that said they should have been evicted by the contract that was written, not what could have happened.
Mr. Sidlaka, let me tell you something. There are a lot of lawyers in the United States of America. I know a lot of lawyers who practice. There are very, very few lawyers that tell a client to go take a hike, that we don't want to represent you anymore. Lawyers are used to dealing with difficult clients.
Judge Judy continues in a moment.
So if you don't like what the judge did, file a complaint. They'll take your complaint, they'll throw it in the garbage.
And later today,
Madam, this is a court. Courts deal with contracts, verbal contracts or written contracts, not what you feel.
real cases, real people. Judge Judy. Attorney Suzanne Taylor is suing property manager Peter Sedlaka for her fees for an eviction case.
What I'm hearing today is that your first lawyer discharged you as a client. That's what you told me.
Yes.
And your second lawyer discharged you as a client.
Yes.
I can understand why. You owe her the money. Now, she sent you a bill for $1,000. You have an item, you have an accounting form?
I have the invoice that I sent on August 7th when I
see it.
discharged him. Since then, it's been interest and collection costs, which are under the retainer agreement.
You received this?
Well, yes, I did.
Good. Did you ever, in writing, question any of the charges here?
For Ms. Taylor?
Yes.
No.
Good.
But I definitely did question the judge not speaking to me. This whole thing could have been settled. When I stood in front of the judge, he said, look, you don't have enough here, even though you got 5 different counts on these people for eviction. Sorry, you can't do it. We stood in front of that judge and we walked out that day. I was not satisfied.
Well, whether you're satisfied or not, that has nothing to do with your paying her.
Oh, I don't mind paying her.
Good!
But that does not negate the fact that I was not I had no due process of law in the
Write a
courtroom
letter to
itself.
Dear Abby, sir. Let me tell you something. Judges don't necessarily hear litigants individually when they're represented by counsel. When I have an attorney before me who's representing somebody and the client opens their mouth and wants to speak, I say to them, sir or madam, you have the following choices. Either you discharge your attorney, in such case you are appearing pro se and I will listen to you. Otherwise, whatever you have to say to me, you say to me through your lawyer.
True.
So if you don't like what the judge did, file a complaint. They'll take your complaint and they'll throw it in the garbage. This lady you're going to pay. And this nonsense counterclaim that because of her mishandling of your case, you lost your building is nonsense.
True. It isn't nonsense, sir.
Of course it is.
Well, then none of this.
Of course it is.
None of these breaches count then. All these breaches.
Just a second.
Yes.
You had 2 lawyers. 2.
True. I'm not. Look, the lawyers. If the judge had just told me that.
This has nothing to do with the judge. The judge isn't on trial here,
No,
sir.
he is. No, he isn't.
That's
but had he
right.
just listened to the breaches that were concerned here, he could have seen that these people should have been gone.
Shoulda, woulda, coulda. He didn't want to hear him that day because you had accepted rent. And once you accept rent, the eviction proceeding is over. Judgment for the plaintiff in the amount of $1,000. That's all.
Parties are excused. You may step out.
All right, no problem.
The fact of the matter is that he sold the building, and he regretted that later, and he was trying to find a way to undo it.
They tell me now that because it's all past the water under the bridge, I can't do it any longer. Only one shot at the brass ring, right?
And now the next case.
Parties on Medeiros versus Roden. Step forward, please.
Bowling League member Julie Medeiros says substitute bowler Wayman Roden owes her half the money won in a Las Vegas tournament. Wayman claims they had no agreement to split the winnings.
You two folks are in a bowling league. Is that right?
Yes.
According to your complaint, there is a tournament, a big tournament held in Las Vegas.
Mm-hmm.
And for personal reasons, you were unable to go. Is that right?
Considering not going, yes.
You were unable to go. The defendant went in your place. You said you had an agreement with him that should the team win, you would receive half of the winnings.
I made an agreement that no matter what the team wins, I get half of the winnings.
Fine. Team won. He refused to give you half the winnings.
True.
Okay. And your defense is what, sir?
Basically what she said, except that I didn't agree to give her half of anything. I agreed to share the winnings with her. But
That's
she's claiming that everything that I received is winnings, and even the IRS will let you deduct your out-of-pocket expenses before they ask for their share.
So what your defense is that you did agree to share the winnings with her.
Right.
But that you had certain out-of-pocket expenses, and some of your out-of-pocket expenses were what you put into the league.
Right.
How much exactly did each team member win?
We received $550 each.
What you say you should be getting $225.
550 I should be getting.
Why?
Pardon me?
Well, just a second. Now, my question to you is, why, if the team won $550, you don't dispute that?
No.
And given the best case scenario for you, that he agreed to give you half the winnings, that's $225. So I don't understand why you are suing him for $525.
Yeah, I'm suing him for $525 because everyone puts into the league throughout the year. And at the end of the season, each person puts in $250 towards their trip there.
Right.
Okay, so I'm out of pocket there, $250.
But he didn't agree to give you that.
No, he didn't. And the only reason that I asked for it was because he then didn't agree to give me what we had verbally agreed upon. So I also asked for the $250, what I was out of pocket, letting him go in my place.
I'm speaking. Madam, this is a court. Courts deal with contracts, verbal contracts or written contracts. Not what you feel, but verbal or written contracts. You had no agreement with him if he went in your place to cover what you had put into the league up until the time of the tournament.
That was not our agreement, no.
It was not your agreement, so you can't sue on it. What are you suing on?
That's what I was asking for.
Well, I just want you to understand
Right.
why I would not consider it, because it's foolishness. It's what a court is. Court deals with contracts. So it's $275.
Judge Judy continues in a moment.
You got a bargain, Mr. Roden, for your $120. For your $120, you got 2 nights stay, and you got 2 meals a day, including 2 banquets. So don't give me nonsense about your $120 when you contributed half of what everybody but 2 people did to go to the league.
Closed captioning, sponsored in part by Real Cases, Real People, Judge Judy. Bowling League member Julie Medeiros is suing substitute bowler Wayman Roden for half the money won in a Las Vegas tournament.
Now, why shouldn't I give her $275?
Because I didn't win $550.
What did you win?
I won $171.
How did you win $171?
I received $550, but I had out-of-pocket expense.
What out-of-pocket expense?
I paid $128 into the league.
Just a minute. Well, so did she. So what? The $128 into the league, sir, listen to me. According to her, each person contributes so much towards going to the tournament.
Right.
Is that right?
Right.
And that's what your $120 was. Right? Going towards going.
It goes into
Listen
the
to me.
prize fund.
Whatever it is. She contributed $250. Put your hand down. She contributed $250. You
Right.
contributed $120. Did you have to contribute any more than the $120?
I didn't have to.
Good. So that she contributed $250, and based at least in part on the fact that she contributed the $250, you were able to go. Is that right?
No.
Yes, sir.
Stop. Listen to me. Listen to me. Does every team member, pay attention, does every team member contribute $250
No.
for the privilege of going through the course of the year?
No.
They contribute different amounts?
Yes.
Based on what?
You pay a certain amount each week that you bowl.
Right, but that has to, are you telling me, Mr. Roden, that every member of the league contributes different amounts?
Okay, I subbed for 3 different people, and I paid into the league during that time. I asked the secretary, how many games do I have to bowl to be eligible to go? She said, you have to bowl 45 games.
Just a second. Are you from the league? Is that
Yes.
you look like you have something to say? Step up here, please. I just have a few questions for you. Tell me your name.
My name's Robin Sloan.
Miss Sloan, how many people are there in this league?
56.
And do you take care of the finances for
Yes.
this? How many people actually go to Las Vegas from your league for the tournament?
56.
And what amount does everybody put into this general fund in order to go?
$250.
No.
Per person.
No way.
Raymond was a sub in the league. He's
Yes.
an alternate.
Right.
So he didn't have a guaranteed spot to go. He was just trying to get enough games in to be eligible to go. He didn't pay $250 into the league, but Julie did, and so did all the other 55 bowlers.
Okay. Now, was he the only sub?
No.
There were other subs. How many?
Yes.
One other.
Okay.
And how much money did he get?
I didn't have arrangement with Cecil, sorry.
Mr. Roden,
Yes.
you're wrong, sir. You're wrong. Now, this $250, what does it go for?
It goes for the hotel, food, and their tournament expense.
Okay. So the hotel, and how many days do you stay at the hotel?
2 nights and 3 days.
Okay. Do you share a room with
Yes,
someone?
it's double occupancy.
Okay. And it pays for a meal allowance?
You get 2 meals, 2 dinner banquets, and then you have 2 brunches.
Okay. And that's what this $250 is for?
Right.
Is that right?
Yes.
You got a bargain, Mr. Roden. Okay. For your $120. For your $120, you got 2 nights stay, and you got 2 meals a day, including 2 banquets. So don't give me nonsense about your $120 when you contributed half of what everybody but 2 people did to go to the league. So what other out-of-pocket expenses did you have?
To get there and back. It's 1,100 miles from my house to Las Vegas.
So who dragged you?
No one.
Good. You didn't have an arrangement with her when you said to her, I'll share the expenses with you. You didn't say, I'll share the expenses with you and deduct from the expenses that I will share with you my gas and wear and tear on my
I didn't tell her
car.
a percentage of anything either. Not 50% or not 1%. I just said I would share.
Well, then,
and do what was
just
right.
a second. Shh. Are you speaking out?
No.
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Well, Mr. Roden, then, based upon what she says, you said you would give her half. Based upon what you say, you will share the winnings with her. So that, let us assume that I believe you. Then that leaves up to the court, not to you, what I believe is fair.
That's right.
Good. And I believe that anything other than a 50% split would be arbitrary, because I could say it could be 40%, it could be 33%. That would be arbitrary of me. Right? If I were to say to you, Mr. Roden, what do you think a fair allocation is, then you would say 30% or 25%, and you would be rewriting this agreement. So somebody has to rewrite the agreement, because you did, according to you, have an agreement to share.
That's correct.
I believe share means 50%. Judgment for the plaintiff, $275. That's all.
Parties are excused. You may step out.
Judge Judy continues in a moment. And on the next Judge Judy.
I offered to give her $122. Well, after I offered it to her, she called me, so I told her that cost her $122.
Well, I think that when you make a verbal agreement with someone, that you should back it up.
We're talking about a man-woman thing here. First wives and second wives don't get along. That's just the way it is.
Like oil and water.
It's the rare case where the first wife and the second wife get along, and the only time that usually happens is when they both hate the husband. Who are you?
The plaintiff.
Well, you're the plaintiff because the car that was allegedly damaged was your car, is that right?
Yes.
But you don't know anything about this, you weren't there.
I wasn't there when.
So why don't you have a seat?
Okay.
Miss Patterson, this gentleman is your former husband, is that correct?
That's correct.
How long have you been divorced?
Since '96.
And you have one child together?
Correct.
How old is that child?
My son is 4.
And you are his present fiancé?
Yes.
Well, in this unfortunate situation, the basics of it are that you went to pick up your son from a period of visitation at their house.
That's correct.
And there was an altercation between you and Miss Robinson. Mm-hmm. You claim that during that altercation, she damaged your car. Is that right?
That's correct.
Okay. So Sunday at 8 o'clock, you arrived to pick him up, and what happened?
Instead of my son coming down, Annette came down and she...
This is Annette.
Correct. And she came to my car and she had my son's boot with her. And I asked where my son was, and she says, I want to talk to you first. And she laid across my car like this, holding the boot, and she kept telling me that I was going to talk to her. I was not going to get my son until I talked to her. She would give me this boot back now and give me back the other one when she received Drew's Nikes back. And
Drew's Nikes, you mean his sneakers?
Correct. And I just didn't want to go through all this. I just wanted to get my child and leave. They have a locked door on their apartment, so I can't, like, I have to sit down there and wait for them to bring my child out. And instead of my child being down there, she came down.
So your complaint says that she scratched the roof of your car with this boot.
Correct.
Let me see the damage to your car. So there's a long scratch on the car.
Correct.
One scratch, is that right? Okay. Miss Robinson, would you mind telling me what you were doing coming down to talk to her?
Mrs. Patterson has made an issue about all the clothing that Andrew wears. So what I did is I just simply went down there to talk to her. She had accused me of giving away Andrew's shoes to their child.
When did she accuse you of giving away his clothes?
Earlier that week. She had called me and asked me where his other shoe was, and I said I'm looking for it. He threw it when he was taking off his shoes and get ready for a bath. So I told him I was still looking for his other shoe, and just give me a minute, or just give me some time, and I'll find the other one.
What else was there in the conversation?
That was it.
Well, that she didn't accuse you of giving away his clothes.
She asked me, well, I think you gave it away to Nellie, which is another little girl Andrew currently plays with and talks a lot about.
Did you ever say that to her?
No, the only reason that got brought up, I asked her about it, is because my son came home saying that Nellie wore his shoes home. So I asked her about that.
So the mother comes to pick up the child after a period of visitation, and you go down there with one shoe. Mm-hmm. Now, what was the purpose of going down there with the one shoe?
Letting her know that the other one was lost. I was very genuine about letting her know. I'm very serious.
The other one of was a pair?
Yeah.
So why didn't you just come downstairs, or why didn't you go downstairs with your son to keep this very calm?
Well, for one thing, I didn't want to get Drew in the middle of an argument because
It wouldn't have been an argument.
She makes an issue out of everything, Your Honor. Everything, and I try to keep Andrew out of it. So
good. Then she should have kept Andrew out of it, and you go downstairs and talk to your ex-wife. I mean, had you been friendly with each other before this incident?
No.
Listen, tell me about the shoe. I don't see how this shoe could have caused the scratches to your car, madam. I really don't.
Okay, I don't know if the shoe does have the eyelets on it and stuff, but I don't know if maybe there was a rock in the bottom of the shoe at the time, or the fact that she does have a big, bulky watch that she wears, and that she was laying across my car like this. So not that it's just that the fact that she did have the shoe in her hand, And that's what was of her body was touching the car, was her arms and the shoe. And she was waving her arms across the top of the car and pounding the shoe on top of my car, telling me that I was not going to get my son until I discussed this issue with her.
Look, there was a big problem about clothes because I read your answer very carefully. I read it and I didn't like it. I didn't like it because originally, according to your answer, you were going to drop off the little boy at his mother's house. Is that right? On that day? Wasn't that your plan?
That's what started, yes.
And then you decided not to do it because of this clothes problem. That's what it says here. Right? We had second thoughts about returning Andrew directly to their house, though, because he was wearing clothes Rick and I bought. Marcia had made a big issue about these clothes often failing to return to us, the ones that we sent. So we decided it would be best to send Andrew home in the clothes that his mother sent him over in. So that means that this little 4-year-old boy comes back from wherever you had him out for the day, and you say you have to get out of those clothes. You have to put on your mommy clothes. These are your daddy clothes. You got to put on your mommy clothes. Is that what you're telling me? Come on. What you're doing by saying that to him is, this is not a nice thing between my mother and my father. They make me change my shoes and my socks and my underwear and my clothes in order to go back to my mother. Don't you see that there's something wrong with that?
Yes, I do.
So why do you do it?
This has been going on for a while. We've been sending him over in clothes and never said anything. We've not gotten any of the clothes back. Or when she sends them back over, they're not even in half the clothes we even sent over. I've never seen them again.
Let me ask you this question, sir. Does she have another 4-year-old child in her house?
No.
So whatever clothes you buy for your son, he's wearing.
Right.
He may be wearing them to school. He may be wearing them out to play. Now, he also, I'm going to ask you one other question. He doesn't come to your house for the start of visitation naked, right?
No, he comes in clothes that are almost 2 sizes too small for him. I mean, I can't even take him to the store after I pick him up. I have to take him home and change him first.
He doesn't come to your house naked.
No, he doesn't.
Okay. So what difference does it make?
Judge Judy will continue in a moment.
Annette, butt out.
And later today,
Now, you got some heck of a nerve to give her $15 Christmas time on a $3,000 debt.
real cases, real people. Judge Judy. Marica Patterson claims her former husband's fiancée, Annette Robinson, scratched her car when she picked up her child.
You see, just so that you'll recognize this, first wives and second wives don't get along. That's just the way it is. They could be both lovely people. It's the rare case where the first wife and the second wife get along, and the only time that that usually happens is when they both hate the husband. That's just the way life is. So you don't send your fiancé down to do your bidding because it's just dumb and counterproductive.
I didn't send her down, Your Honor. She made that choice to go down.
Well, that was ridiculous. And it shouldn't happen again. Because if you return Andrew to his mother when she's been agitated by something that your fiancé does, who do you think's going to suffer? You're supposed to try to alleviate whatever stressors you can. This is a stressor. Now, you may not be able to alleviate the stressors that exist between the two of you, although that's really dumb, because if he wasn't a great guy for you, maybe a great guy for this lady, but he wasn't great for you. You have a nice new husband? You happy?
Yeah.
Terrific. He's going to have a nice new wife. He's going to be happy. Terrific. You happen to have a child together that's going to tie you together for the next 30 years probably, or more. So you try to get along.
We didn't have any problems for a long time until she came along and started trying to maneuver and instigate and make decisions and do things. We really didn't have a problem between the both of us.
The main reason that Annette kind of took over on some of the things is because whenever I would take Andrew down with me, she would chew on me right in front of Andrew.
That
So I
is
didn't want that.
unacceptable. Listen to me. When the child is there, nobody is to say anything negative or that would precipitate an argument. Hello, how are you? Did you have a nice time? Thank you very much. I'd like to speak to you. Give me a buzz later in the house. Period. And when you take the call, take it and make sure that Andrew isn't around. Both of you. It's as simple as that. You should have absolutely no reason to have any negative conversation with him.
When I go to pick him up, I don't talk to them at all. I just take my son and leave. It's when she comes down to the car and my child's not there, I don't have a choice. I don't wish to speak
Has
with
this
them.
happened before?
With Annette coming down to my car, yes. This happened 2 other times that she came down to my car and they held my son in the apartment.
For what reason?
So I would talk to her about whatever issues they felt were issues at the time.
Annette, butt out. It's none of your business. 0. You have no business getting yourself involved and injecting yourself into their life. Absolutely none. Listen to me. Don't be a wimp. Don't send her down to do your work. To send this lady, seems like a nice lady, down to do your job, understanding the premise that I started with today was first wives and second wives usually don't get along, is a very foolish thing to do and not good for your son. And certainly not over clothes. It's not such a big deal. I mean, I don't know whether you send him over in clothes that are not of good quality. If you're doing it to be a little spiteful and to give him a dig, don't do it because it's hurtful to your child. But they're his clothes. They're not your clothes. They're not her clothes. They're his clothes, and he's wearing them. Stop making a big deal about it. This is nonsense. Hey, Miss Patterson, you have another child now. You have a daughter, right? I assume that you would scratch the eyes out of any person who tried to emotionally harm either of your 2 children. Is that right?
That's correct.
And that's the way you should feel as well. When he hears either parent talking badly about the other, even when you're talking to his father on the phone, that does not make him feel good. If you're doing it, stop. That's all.
Parties are excused. You may step out.
America is just jealous of Annette more than anything is what I think it is. She thinks that she's, jealous that maybe Andrew might like her more or something. I'm not sure exactly what it is.
The truth of it being is we take very good care of that child. He don't pay child support. He's over 3 years back behind child support.
And now the next case.
All parties on Bates versus Barkdull. Step forward, please.
Retiree Alga Bates claims 40-year-old waitress Sharon Barkdull owes her over $3,000. Sharon claims Alga is trying to ruin her life.
Miss Bates, according to your complaint, the defendant was a neighbor of yours and became a friend. Is that right?
Yes, Your Honor.
And according to your complaint, she told you that she had some financial problems.
Yes, Your
and
Honor.
that you loaned her, in a series of loans, $3,025. Is that right?
No, Your Honor. We loaned her $3,840, and she paid back $815, which left a balance still to be paid of $3,025.
Thank you. Okay, now, Ms. Barkdull, you acknowledge in your answer to her complaint that you borrowed this money.
Yes.
And you say, however, that after you borrowed the money, she became controlling of your life, caused you a lot of stress. Therefore, you are not going to pay her a penny. And in addition, you're countersuing for $5,000 for nuisance, harassment, pain, and suffering. So, Ms. Bates, you don't have to say anything. She's acknowledged that she borrowed the money. She's acknowledged that the outstanding amount is $3,025. Is that right?
That's correct.
Judge Judy will continue in a moment.
How dare you have a Christmas party when you still owe her $3,000? You got some heck of a nerve. I mean, if you're a big girl and you don't want somebody to act like your mother, start growing up.
Closed captioning sponsored in part by Real cases, real people. Judge Judy. Alga Bates is suing Sharon Barkdale for the return of over $3,000 in loans.
Okay, now, Miss Barkdale, convince me.
All right. In December, Olga and I were very good friends, and at that time, she had become controlling of my life. She was like a mother figure to me. I felt very close to her, but the more that I felt close to her, the more controlling she became over me. So at that point, I severed the relationship. I felt like she wanted to sever the relationship, and I was still paying her small amounts of money until one day I went to work and she left a message on my machine saying that if I didn't pay her more money, that she was going to have me fired from the Hyatt, or go to the Hyatt, excuse me, not fired, go to the Hyatt and tell my employer that I owed her this money. So I wrote her a letter saying, please don't do that, because if you do that, it's going to cause these problems. Number one, they don't want to hear personal problems. Number two, if you do that, I'll get fired and I won't have a job to pay you back. And number three, here's $15 intent to pay, and let's work through this. So after that happened, I had a Christmas tree in my house, and I had sent out some invitations for a party. I left a cocktail notice on one of the neighbors upstairs, and she went and got it off his door and called him in LA and told him that I was having a cocktail party. She then leaves a recording, 2 different recordings on my answering machine, saying that, oh, you have this big cocktail party, you know, you owe me this money, surely you're not paying for it. Then her husband left a message after that saying, we do not want anything to do with you anymore. So I said, fine, if that's what this is about. So I went and got a restraining order on her, a temporary restraining order, because she was walking past me and saying, oh, there's the girl having the big cocktail Christmas party. And I mean, and it was just ridiculous. It was like all I wanted to do was continue paying her.
Just a minute. Give me the best reason you have for not paying her.
The best reason is I got fired from the Hyatt Hotel, and where am I going to get the money to pay her now?
Did you get fired because of her?
I believe I did.
No. Well, then, if you believe you did, you got fired because of her, why don't you tell me how?
Because she left a message on my machine saying to me, and it was like on a Friday, and she said, if you don't pay me the money that you owe me, I am going to the Hyatt Hotel, and I'm going to tell them that you owe me this money.
Okay.
Judge Judy will continue in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Here we go. A, your countersuit is dismissed. It's nonsense. If you don't like the way somebody is talking to you, this is not nuisance, harassment, or anything else. It's somebody who's trying to give you some advice, even though you didn't ask for it. You're a big girl. If you don't like the advice, you don't listen to it and tell her, I don't want to listen to your advice. Don't talk to me anymore. That's not nuisance. That's not harassment. And certainly the only pain and suffering that I see in this case is from these 2 people that lent you money. Now, you got some heck of a nerve to give her $15 Christmas time on a $3,000 debt, $3,000, and then go out and have a party in your house. Big party, little party. You went out and bought invitations. You went out and mailed the invitations. You had a party. You served liquor. You served food. You had to spend at least $100. Can't do a party for less. Right, Bert?
No, not doing
No.
that.
No. Can't do a party for less. How dare you have a Christmas party when you still owe her $3,000? You got some heck of a nerve. I mean, if you're a big girl and you don't want somebody to act like your mother, start growing up. Judgment in this case is for the plaintiff in the amount of $3,025.
Parties are excused. You may step out.
Judge Judy will continue in a moment. And on the next Judge Judy.
We were used. I feel that we were betrayed. Out of the kindness of our heart, she came to us pleading for help, and we gave it to her, and that she could do this to me.
I don't feel I took advantage of them. No, I had every intention of paying them back.
The courts do not differentiate between fathers and mothers with regard to paying child support. Who do you think should provide you with a roof over your head, except you?
Myself, definitely.
Perfect.
I agree.
So you don't get any medals for that. That's what you're supposed to do.
Women of substance.
Women, they should always make sure that they can take care of themselves.
I completely agree, Your Honor.
So,
I completely agree.
Boy, girl?
Girl.
You are suing the defendant for back child support.
Yes, Your Honor.
What does she owe you?
$13.28.
There is a counterclaim here by Ms. Mayhew for some old utility bill.
Correct.
And for some other nonsense. All right, Mr. Mayhew, how long has your daughter been in your custody?
Since she was born, and then when she left in October of 98, 7.
Do you visit with your daughter?
Yes, I do.
Okay. I read in your answer what seemed to be a suggestion that you do owe him money for child support. Is that right?
Yes, the first 2 months. I paid him little bits, $50, $30.
And then you say you've been consistent with your payments
I have been
since?
consistent with all of my payments.
Show me.
I have a list here of the time and dates that I paid, and I have a few, I'll let you have it, money order stubs that I have. That's the only receipts. I don't have receipts. I paid him cash the whole year.
Did she pay you cash the whole year, sir?
No, she didn't. I have a breakdown of what she did pay.
And also, here's another one for, I put her in daycare. She's in daycare this month. That's my...
Well, what does your judgment of divorce provide for with regard to payments?
$158 a month.
And it's your testimony that but for the first couple of months you were regular in your payments?
I was supposed to start paying in February. I did not start paying until the middle of March.
No, that's wrong, Your Honor. She didn't start paying until August.
Miss Mayhew, you see you have a problem. Let me tell you what your problem is. When somebody sues for back child support, he says you haven't paid. You have some receipts that you did make payments, and he says you did make certain payments. So you are going to have to establish to me that you made these payments, because most people, when they make child support payments, they make payments by check.
I trusted him. I was with him since I was 15 years old. When I left him, I did not have a job. I did not have any direction at all whatsoever. As soon as I did start working full-time, I paid him. She's my daughter. I was an at-home mother with her for 2.5 years. I would not be a loser mom and not pay my child support, period. He is lying. I paid him, period. I have my witness, has been there a few times.
Well, I'll hear your witness.
She also has heard him say that he's going to get me back for anything he can because I messed him up. He wants to, screw me over.
What's your name?
Allison Noah.
Miss Noah, can you recall dates, times, and places where you saw exchanges of cash between the plaintiff and the defendant?
I know for sure on August 3rd, their daughter's birthday, I went to their daughter's birthday party, and I saw her pay him $80 in cash that day.
That's not correct, Your Honor. She never gave me any money on her birthday. Her father, I guess, offered to pay me $60 towards the birthday party, and I refused to take it. I paid for the whole birthday party and everything. She never gave me any cash during that time.
Did you see her?
Yes, I saw
give
her
him
give
cash?
him money. Yes.
At any other time, did you see him accept cash from her, and in what amounts?
One other time in October, my daughter and I were with her and her daughter, and we were in her car taking her daughter to his house. And she gave him, I saw her take cash up to him. I assumed it was $80 because that's how much.
You didn't know how much it was, but you saw him actually accept
Yes.
money. Yes. Do you recall that?
It wasn't cash, it was one of the vouchers that she has up there, one of the receipts, because she was paying at that time.
No, it was cash,
No,
Your Honor.
it's not
It was
here.
cash.
This is not I don't have an October date there. She has 4
And the only reason I don't have
amounts.
receipts is leaving him, divorcing him, I was left with tons of creditors. I did not have a bank account. People were trying to garnish my wages, what little money I was making. I did it out of good faith. I mean, I've known him for, years. I gave him the money,
Mr. Mayhew,
yes.
Listen to me, sir. You just testified that you didn't get this payment that she's referring to in October. Is that what you're saying?
Right, I got it in a money order. I got money orders September, October, November, and December, and January, and then my wife served her with the court documents here, and she stopped paying, so I didn't receive anything from this year in February or March.
Ms. Mayhew, you say that you missed a couple of months
In
initially.
98, the beginning of 98.
Just a second.
Okay.
And other than that, you say you were current.
Yes.
Oh.
Every paycheck I got, he was my first person I paid.
Okay.
And the only reason...
Listen to me. Shh, listen to me. I'm getting somewhere.
Okay.
Did you pay him in January of 99?
Yes.
Did you pay him in February of 99?
Yes.
Show me.
I don't have proof of it.
Now I'm going to tell you why. If you're not honest with me right from the get-go, then you always catch yourself. Because you said to me, other than the first couple of months, I've paid him regularly. Then problems started at the beginning of this year, the beginning of 99. When were you served with a summons for back child support in the family court? In what month?
I'm really not even sure.
You have a witness?
Yes,
Can
I
you
do.
tell me? Step up, please. You're Ms. Mayhew?
Yes.
When did you serve the defendant with the summons for the family court on the issue of back child support?
In February, early February. I don't have the exact date. We filed on February 1st.
Okay.
You served her that night.
And I served her that night, so February 1st.
Okay. Now, one of the problems that I have, Ms. Mayhew, is you did not pay in February at all, and I'm going to tell you why I know that. Because according to the papers that you give me, you show that you have made payments in December, January 19th, 1999, and January 5th, 1999. Okay? So you made 2 payments in January, but clearly you made no payments for February. And did you make any payments thus far in March?
No.
All right. So that clearly there's at least a couple of months that you didn't pay him in September, according to you. Clearly, you made no payments in February, and clearly you made no payments in March.
No.
And you didn't make any payments at the beginning, in September and
No, I did not.
October. Okay. For the first couple of months at least.
The main reason I didn't is he told me he wanted to garnish my wages. That's how it should have been in the beginning. I said, you want money from me? Garnish my wages. Since he's met his new wife, he took, Casey from me. I had her 50% of the time, and after that, it just all went downhill.
Judge Judy will continue in a moment.
Ms. Mayhew, who do you think should provide you with a roof over your head? Except you.
Myself, definitely,
Perfect.
I agree.
So you don't get any medals for that. That's what you're supposed to do.
You're right.
Real cases, real people. Judge Judy. Sean Mayhew is suing his ex-wife, Amber Mayhew, for back child support. Amber is countersuing for utilities.
All right.
Your Honor?
Yes.
Okay. I filed through the state to petition to garnish her wages because every time she would come over and make a payment, we would get in a fight.
You don't have to necessarily garnish her salary. That can come if she doesn't pay. Clearly she hasn't paid. They're going to garnish her wages now and have the payments made directly through the court. You don't necessarily have to get her employer involved. If she was paying directly, she could just make the payments through the court.
Right.
So that there would be a record. So that you both learned a very interesting lesson. And the lesson is you're supposed to have receipts, but you owe them a lot of money. Because you owe them a lot of money, taking what you say as true, at least part of it.
I swear to God, Your Honor.
No. Listen to me. Taking what you say is true that we found out today. You haven't paid him for a couple of months when you started. You didn't pay him in February, and you didn't pay him in March. The grand total of that is $1,040. Okay, that's a lot of money. Now let's get to your counterclaim.
Where did you think I'm not paying? Where I missed that.
Where? Don't miss it. Did you give him money in November?
I was not ordered to pay him.
I didn't ask you whether you were ordered. That's not my question.
No, I did not, Your Honor.
Did you give him money in December of 97?
No, I did not.
January of 98?
No, I did not.
February of 98?
No, I did not.
Well, you mean you just told me a moment ago that you didn't have to be ordered by anybody. You know that you have a responsibility. You wouldn't just be a deadbeat mother. And I'm going to tell you, there's a lot of talk about deadbeat fathers when they leave and they don't pay until they're ordered to pay. You said to me that I wasn't under an order to pay. That doesn't mean you don't pay child support. That doesn't mean you don't say...
I completely agree, Your Honor.
So?
I completely agree.
So stop complaining. How many months did you get away with not sending support until you
didn't get
ordered?
away with not
Sure you
sending
did.
support.
Did they make a retroactive order in the court? Did they make
No.
a retroactive order? Well, they should have. If you were before me, you
Yeah,
would have gotten a retroactive order from the time you didn't pay. The courts do not differentiate between fathers and mothers with regard to paying child support. Both parents are responsible to pay child
Definitely.
support.
Definitely,
If you
I
walk
agree.
if you walk out of a marriage, that's your prerogative, but you can't walk out of your responsibility to support your child. Now let's get to this ridiculous utility bill that you have here that you counterclaim. You say when I split up, he was to take care of the utility bill, and he did not. You want to tell me about that?
Him and his ex-girlfriend Pam were living there. She moved in a week, 2 after I moved out.
Show me.
I'm being sued for the amount here. And
For what amount?
I asked him for the PGE bill. I'm there now.
Well, show me. What dates? I assume there are dates on that.
There might not be, just the amount.
Well, what am I supposed to do with this? You say it was at a time when they were living there and you were not.
Yeah, I had
Show
taken
me.
myself off the lease. That's all I had. It was an old bill. It was from 97 into 98. It was approximately 3 months worth of PGE, and he was supposed to have put it in his name, and he didn't. And it was my irresponsibility not turning it off in my name.
Did you pay the utility bills?
Yes, I paid for everything. She had her mail forwarded. I never got a bill for it. I tried to get in contact with her, but the first 2
You never
months,
shut
she
it off
never.
in your name.
Just a second.
I can't shut the electricity bill off when it's in somebody else's name.
In what month did you put the electric bill in your name?
I think it was January.
Okay. So for the months of October, November, and December,
Right.
it was in her name.
Right.
Okay, and you did not pay those bills because you did not get those bills.
Right.
Is that correct?
That is correct.
All right. Well, then you have to pay the electricity bill. But you
Okay.
won't, right?
Right. I can
Good.
understand that to the point.
Perfect.
Except for that, she stuck me with I have to pay for a babysitter because she took off right away on the
Live-in
spur of a moment.
babysitter.
Hey, don't
No.
talk to him. Don't talk to him.
Excuse me, sorry, Your Honor.
So
we don't
I was
upset.
already living check to check.
Listen
so
to me.
And I was living with nothing. Excuse me.
You have to pay for the electric because you use it. You're not going to offset that because of a babysitter. This is your child. Are you happy having your daughter with you?
Oh, yes.
Perfect. And your daughter is fine?
Yes.
Perfect. Let me make some clear suggestions to you folks. I'm giving her credit for the utility bill, which is $350. I am not giving you missed work of $150. That's absolutely ridiculous. You probably caused more missed work for him than I guarantee you this
I
utility
supported
bill.
a 2-bedroom apartment all by myself, so taking a
Well,
day
who do you
off
want?
of work was
Who do you-
very intense.
Let me ask Miss Mayhew, who do you think should provide you with a roof over your head, except you?
Myself, definitely,
Perfect.
I agree.
So you don't get any medals
All
for that.
right,
That's what
all
you're
right.
supposed to do.
You're right. Well, I was with him for 5 years, and that was like...
What?
It was a struggle for me. I'm very proud of myself. I'm very honored to say that I take care of a nice 2-bedroom apartment and have my own car and pay my own insurance and pay all of my own bills, and I'm not depending on anybody, and I still
Well,
paid
that's
him
what
the
you
money.
should be. That's what all people
Definitely,
should be,
but I'm
especially women.
proud. What can I say?
Especially women. They should always make
Yeah.
sure that they can take care of themselves.
Judge Judy will continue. And later today,
And what you said to me, and the answer was, this is between brother and sister.
closed captioning sponsored in part by Real Cases, Real People, Judge Judy. Sean Mayhew is suing his ex-wife, Amber Mayhew, for back child support. Amber is countersuing for utilities.
I'm going to make the following suggestion. That any monies that you give him by certified check, by money order, keep a receipt, or by personal check, which you will get back from him. That you do not accept any cash from her, ever. I'm giving you certain credit for the utility bill of $350. I'm offsetting that against what I believe is a reasonable adjustment of the plaintiff's claim for back child support, and I'm awarding you, sir, $700. That's all.
Thank you, Your Honor.
This case basically shows that not all dads are deadbeat dads, and they could be the mother, too.
He said that he was going to do whatever he could to get me back, I screwed him, and, he was going to screw me.
And now the next case.
All parties on Neiman versus Brown. Step forward, please.
29-year-old teacher Kimberly Neiman and her husband, 36-year-old driving instructor, Frederick Neiman, are suing Kimberly's father, 59-year-old Kenneth Brown, for a credit card he used to start a business with her brother.
I hate it when families sue each other. So, Miss Neiman, this is your dad. Is that right?
Yes.
And according to your complaint, some time ago, your dad asked to borrow some money from you.
That's correct.
Is that right?
Mm-hmm.
And you gave him a credit card.
Mm-hmm. That's correct.
And bill is way past now $5,000. And you want him to pay the bill. Okay, Mr. Brown.
I did ask to borrow the credit card. It was a bit small business.
I know that you have a daughter. According to your answer, you also have a son.
Yeah,
Was the credit card for your son's use or for your use?
for his use.
So why didn't he ask his sister to borrow the card?
They feud and fight.
What did you say to them when you borrowed the credit card?
I told her that Ken would be using it. His name is the same as mine.
Well, your problem, Mr. Brown, is I read your answer. And what you said to me in the answer was, this is between brother and sister.
Yeah.
You borrowed the credit card. You allowed your son to use it. You say she knew that he was going to use it for a business. Was this business that the two of you were starting together, you and your son?
Yeah, him and I originally, but then we collapsed it.
You have to pay the bill. And then if you feel as if your son owes you money because you had to take on this responsibility, you might have to do what she's doing now. But the card was given to you.
Correct. I just feel that the two of them knew what they were doing, both of them, both sides, that they ought to be dealing with each other.
Well, she knew what she was doing. She was loaning her father her credit card. Is that right?
That's correct.
And according to you, she and her brother didn't get along. Is that right?
Right.
So it's possible that if her brother came to her and said, I'd like to borrow a clean credit card that has a full line of credit, she would have said no. Right?
Possibly.
So you understand, sir, the reason that the credit card was given was because you asked for it. She was relying on you to pay off the bill. She wouldn't have given the credit card to your son. He probably knew that.
Yeah.
Judge Judy will continue in a moment. Are you in a family dispute? Call 1-888-800-JUDY. On the internet, judgejudy.com.
So let me see the balance on the credit card.
This is the newest one. The balance is right.
Have you made any payments at all on these bills?
I have, yeah.
You have?
But they have paid me back. I have other credit cards that they owe me money on.
They advised you almost a year ago that they were removing you as an authorized user of the account. Is that right?
Yeah, we requested that.
You
yeah.
requested that.
Mm-hmm.
Are any of these bills after they
There
were
has-
removed as an authorized user of the account?
There hasn't been anything since
There
then.
hasn't been anything after that? Okay. Well, this is well over the $5,000 limit, Mr. Brown. But this is your responsibility. And if you feel as if the business didn't go anywhere that you and your son went to, it failed?
Yeah.
Is that what happened?
Yes.
Well, that's not their fault. Judgment in this case is for the plaintiff in the amount of $5,000. That's all.
Parties excused, you may step out.
Judge Judy will continue in a moment. And on the next Judge Judy.
I'd like everybody to get along, but I think it's going to be very hard, very difficult,
Well, I've been called everything but a nice guy by two kids that I raised.
because nobody wants to be responsible for their own actions.
When I started banging on his door. This is the second incident of him pounding.
Anybody home?
He claims it was banging. I call it knocking.
It was banging, sir.
I touched his door,
His
touched
door.
his door?
Okay. The two of you been neighbors
Since December.
of 1990?
8, ma'am.
And how long have you been living on that property, sir?
I've been in my home for 19 years.
So you just moved in?
Yes, ma'am.
Evidently, there's some major parking problem here. Is that right?
Yes.
Correct.
Now, is there a garage where the two of you park your car?
No, we have assigned spots. They are small. And
But
somewhat,
outdoor spots?
Yes.
Okay, and your spot is next to Mr. Clark's.
One of my spots.
He's actually got 3 spots.
Good for him. He's been there 19 times as long as you have, so now he has 3 spots.
Right.
But one of his spots is next to your spot.
Correct.
And I gather that from the time Mr. Clark moved in, there has been an ongoing problem. Is that right?
Yes, it's very difficult to park in the back. I don't have much problem as I have a compact car, an '87 Honda. And the Clarks have a pickup truck, somewhat large, but...
it's a Ranger. It's a small truck. It's not a big truck.
It's a truck.
Right.
It's bigger than his car.
Not really, Your Honor. It's a light-duty truck. Doesn't have a standard cab. It's not very big. It doesn't take up a lot of parking spot. I mean...
Okay, but you've had ongoing problems with each other about this spot, about hanging over a little bit on his side and hanging over a little bit on your side. So this problem started. You got angry one day at him.
Correct.
I'm not going to go into the whole history of it. He says you came banging at his door.
Correct.
And you damaged the door. So, what brought you to his door?
Well, the fact that he parked in my parking spot intentionally, just to be snippy, just to instigate an incident. So I got mad at it. So I parked off street and I went up to his door and I started banging on his door. Now, when I banged on his door, I noticed that it was loose and damaged up top, so I began to bang on the bottom. So, I'm banging on, I'm telling him to come out, and, so he can move his car. Now, before I went up, I noticed there was a letter hanging on his window saying, I have video footage of my car. If there's any damage, I will take you to court, as if I was going to do something to his car, which I wasn't. I just wanted him to move it. And that's what I was asking him to do. The whole time I'm yelling up to his window, please move your car, please move your car. Now, he mentions in his letter that I made a homophobic remark to him, which I did, and I apologized to him for that. I had no right to say that to him. But other than that, as far as the damage to his door, it never happened. And I have a witness, my wife, went up to his house. He was having interior work done, and he had invited her to his house. This was in December when we were on okay terms. And she noticed, and she can testify that his door was already, and it's rusted up top, and he already had damage done to his door. Because when I spoke to the detective...
Don't tell me what the detective said.
Okay.
Now, Mr. Nacera, he says, and you seem to indicate as well, that just prior to that, he had parked in your space or a little bit over your space. You went up to tell him to move his car, or you called to tell him to move his car, and he was in the shower. Is that right?
That's correct. That was that same day.
The same day. And your wife was at home?
Yes, Your Honor.
You drive?
No, I don't.
And you said, wait until I get out of the shower.
Right. Actually, I knew the car was not parked in the spot. When I had went out there after the shower, 1/4 of an inch on the white line. On the white line. The white line's about this thick. My tires were 1/4 of an inch on the white line, not in his parking spot.
Does that sound familiar to you, that you had had a complaint that day?
Pretty much. That is, as I say, it is very difficult to get into those spots. Often the Clarks will park on the white line or in the white line on the front and slightly over the white line in the back. That makes it impossible.
There's bars in the way. There's no way I can...
Now, Mr. Nacera, according to Mr. Clark, sir, there was a time when you were friendly with his wife.
Yes, sure.
Until when?
Well, since December, there were incidences of where the car was parked over the line, either the front or the back. And Mr. Clark chooses to leave his tailgate down, which adds about 1.5 feet to the car, his truck. It makes it very difficult to get in, even with my Honda Civic. On that day that he says he's mistaken, I was in my spot, not over the line. I mean, I wouldn't purposely. I have pictures, Your Honor. I have a videotape.
And you'll actually see on the pictures that the door is actually ripped out.
Just a second, I haven't seen
anything. I don't know how
anything.
banging caused that.
I haven't seen anything. It depends upon how hard you bang, sir.
Let's see. This is the wall inside, Your Honor, the damage that was done to inside my home.
How did he cause damage inside as a result of the banging?
Yes, he started off banging pretty hard. somewhere about 10 minutes into this incident, he was pounding on the door, pounding on my window, ringing the doorbell.
Is that when he made this homophobic remark?
Yes, he was quite outraged, and he was saying pretty bad stuff. I don't know if I can repeat it here. There was a lot of F words, but he was very, very angry. And I was not about to open the door. In fact, I was on the 911 call, having the police come to try to work something out here. And the operator, in fact, heard the commotion and advised me not to.
Does the videotape have any part of this banging on the door?
Yes, it
sure
does.
May I see it, please?
On February the 15th, at somewhere between 11:30, 12 o'clock on that night, when he vandalized my door, you'll see a few seconds of it because it's going to be very dark, and you may see.
He never opened the door.
You begin to see
That's.
He came up about 12 o'clock last night. He was banging on the door and banging on the door and banging on the door and ringing the doorbell. I mean, he was just livid. This is the second incident of him pounding, which I
want to listen.
Can you answer the door, please? Very violent.
I think
it's the downstairs neighbor in 103. This is the second time. The last time he smashed my security door and caused damage to the wall inside. And now he's wanting me to come out and talk to him. I do not.
I think that is basically it.
And the second time I actually responded to that second time when I came to his door, it's because he sent me this letter in the mail. And at the bottom he puts, P.S. You are asked to respond to this letter in the normal time allowed. I don't get letters all the time, but I figured, okay, maybe he calmed down and maybe he wants to speak to the incident. So I originally sent my wife up there to speak to him because I figured maybe he doesn't want to talk to me. And so he shuts the door on my wife, and then I thought, well, maybe he just wants to deal with me because it's between me and her.
No, you didn't. You got angry that he shut the door on your wife. Mr. Clark.
No, it wasn't because of that, Your Honor. It wasn't because I thought maybe he wants to speak to me. So when I went up, I even asked him, can you see it in the tape, can you please open the door? He claims it was banging. I call it knocking, but I mean, I probably should have caused an earthquake, according to him.
Judge Judy continues in a moment.
I said I touched his door. His door? Okay.
You didn't touch his door.
And later today.
You also say that you want to pay the money back.
Verbally.
As opposed to what?
Written contract.
You go to law school in between you driving a limousine?
Real cases, real people. Judge Judy. Sal knows Sarah wants his neighbor, James Clark, to pay for his damaged front door. James says Sal parked in his space, but he didn't damage the door.
Your Honor, I have tried also mediation through the court. Mr. Clark refused. I have that here. I have the police officer's report, the detective's report. I have estimates of the work.
Let me see. When did this incident occur? February of ¡99?
Yes, that would be the 15th. The second one was, I think, the 22nd, as indicated on the videotape.
I have to read something, Mr. Nacera. All right. The police officer noticed the following and made note of the following in his police report. He took a picture of the damage to the screen door. He also noted that the screen was pulled out from the frame about 6 inches and the securing welds had been broken. I checked the door frame and noticed 2 stress cracks about 8 inches long in the upper right-hand corner of the door frame. The plaintiff advised me that the cracks were not there before Clark's knocking and the banging incident. We're not talking about rust here to the door, sir. We're talking about a door being knocked off the welds, and we're talking about stress cracks. Now, do you have an estimate?
Yes, there are 2 estimates from 2 different places on the replacement of the security door. The other estimate is from the painter who painted. I saved 2.5 years to have my unit painted, And may I also, Judge, note that Mr. Clark did not apologize to me. However, he did say to the police officer that he did call me faggot.
I tried to apologize to him the second time I came up to his door, and he wouldn't answer it. He put in the letter that he wanted me to respond to it, and when I went up there, I told him that I apologized for making the homophobic remarks. That was it.
Well,
I didn't apologize for damage.
You can understand, sir, and I read what the remarks were, and they were pretty egregious. You could understand why he would not open the door if you're screaming that to him through his door.
That was the first time.
I'm talking about the first time. The first time is the time that I understand that this damage was done to the property. Is that right?
Yes, that's correct.
Well, fine. So would you please indicate to me exactly what it cost to have this door repaired as well as...
Yes, right. The door cannot be repaired.
So you have to get a new door?
Yes, ma'am. It
And
has
how
to
much
be
is
installed.
What is the cost of the door?
According to, I have two. One is from a local place, $250 plus a $50 delivery charge. The other is from Home Depot, comes to $272.96.
And what about the replastering of the...
That was $70. It's indicated on...
Okay.
How could I have caused damage to his wall?
Mr. Clark, let me tell you something. When you lose your temper, which you clearly did on that evening, you lost your temper. Whatever the consequences are, it's going to be very difficult for you to establish to me, since he has testified that this was not there before. Is that right?
That's correct.
The fact that you say that it was an old door and that it was rusted on top, that has absolutely no consequence.
But my wife saw that the door was busted when she went up there. I mean, way before this incident happened, Your Honor. She saw the door. She saw his apartment complex. She saw it was being worked on by interior decorators.
Did you check the welding on the door when you went up there?
No, I didn't, Your Honor.
She didn't check the welding on the door. This is an old door.
She's
not saying it's a new door.
She can see that the door is broken, loose up top. She doesn't have to see all the rivets.
I want to tell you something. If your wife was to stand there and tell me that she noticed when she went up there on a social visit that the welding that held the door in place was broken, I wouldn't believe her, and I wouldn't even ask her
But
that
it was
question.
already broken, so when I went to bang on the door, of course it's going to bang. It's going to get even more loose.
Oh, then you're responsible.
I'm not responsible.
No, you are responsible. If
his door was already damaged.
Mr.
How
Clark,
could I have made damage to something that's already damaged?
You're not paying attention, sir. Did you hear what you just said? You just said if the door was already damaged, and because I banged on it, it was damaged further. I'm not responsible.
No.
That's exactly what you said to me.
I said I touched his door.
His door?
Okay.
You didn't touch his door.
His door was already damaged. I mean, how can I not knock on it and for it to not get loose? That's just not physically possible.
Mr.
His
Clark.
door was already broken, so I'm banging on it. It's already broken, so I'm not gonna. I mean, how could I have broken it?
Judgment for the plaintiff in the amount of $340. Thank you.
Parties are excused. You may step out.
Thanks. I've been there 19 years. It's a nice small complex. We're sort of very tightly knit. I would like the Clarks to fit in if we can only work out the parking situation.
I can put it behind me, but yeah, I mean, I'm not going to talk to the guy as far as I'm concerned. He's just a neighbor.
And now the next case.
All parties on Black versus Hamilton. Step forward, please.
35-year-old limousine company owner Dolores Black is suing former driver David Hamilton for a loan. David is countersuing for the cost of Armani suits he used for uniforms.
Ms. Black, you own a limousine company?
That's correct.
And according to your complaint, the defendant was an employee of yours for some time. How long?
Off and on for a few years.
As a driver?
That's correct.
You loaned him some money, $2,000.
Yes,
He had
I
some
did.
financial difficulties. He paid you back $500, according to you, after you made some repeated attempts to try to collect the debt, and he still owes you $1,500.
That's correct.
Now, Mr. Hamilton, I read your answer. So your answer says that, well, you had some financial difficulties, and you acknowledge, sir, that you borrowed this money from the plaintiff. So far, is that right?
So far, so good.
You also say that you ought to pay the money back, right?
Verbally.
As opposed to what?
Written contract.
You go to law school in between your driving a limousine?
Judge Judy continues in a moment.
You say that as part of your job, you were required to look nice.
Expected.
Bought yourself an Armani suit? Brooks Brothers suit. A Canali suit. Then we got white shirts.
Perry Ellis.
Closed captioning, sponsored in part by Real Cases, Real People, Judge Judy. Limousine company owner Dolores Black is suing former driver David Hamilton for a loan. David wants Dolores to pay for his designer uniforms.
Now, was there any time set for the repayment of this loan, Ms. Black?
Yes, there was.
What was the time?
By the end of the month.
By the end of the month?
July of '98, that's correct.
Does that sound right to you?
No.
So you disagree on that, but it's not particularly relevant. Now, what I loved about your response was your counterclaim. You say that as part of your job, you were required to look nice.
Expected.
And that there was an agreement that the plaintiff would reimburse you 50% for your employee uniforms.
That's true.
Is that correct?
To a certain amount, that is correct.
Did he ever furnish you with bills for his uniforms?
No, he did not. And in fact, the employment contract states up to $150, which he signed, and Lonnie, an employee of the company, is the witness to that.
So here we go, and this is the best part. This is what your countersuit is. By the way, you do drive a limousine, which means you're supposed to be in a dark suit, right?
Correct.
Right. Nice black suit, and a white shirt, and a tie. Any color that you like, as long as it's conservative and it doesn't have a picture of Pluto on the front, right?
It depends who you're driving that week.
Bought yourself an Armani suit
Yes, ma'am.
for $1,200? Got good taste. Brooks Brothers suit, $700. This guy's got quite a sense of humor. A Canali suit for $700. How much money did you earn?
Average was probably $8 an hour. Gratuities could exceed $10 an hour on top of that.
So the grand total of $18 an hour, that doesn't require an Armani suit for $1,200. Then we got white shirts. 10 shirts you bought at $40 a shirt.
Perry Ellis.
Love it. Now, this one would really send my husband into a tailspin. You know, he likes those ties 3 for $10 that you buy, you know. 6 ties at $45 a piece, $270. And here we go. This is almost my favorite. 2 pairs of shoes at $210 a pair. You don't even walk around as a limousine driver.
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Your lawsuit's the most ridiculous thing I ever saw. I mean, I think you're probably almost embarrassed when you had to sign it. Now, why didn't you pay it back for $1,500?
Financial difficulties.
How'd you pay for your Armani suit?
You gotta look nice.
How did you pay for your Armani suit?
Paid for it in full.
How?
Cash or check.
I can't deal with him. Judgment for the plaintiff in the amount of $1,500.
Parties are excused. You may step out.
Judge Judy continues in a moment. And on the next Judge Judy.
I think she was very fair. I'm very pleased with the judgment.
It happened so quickly that, you know, I didn't have enough time to dance.
He was a very good employee. He's very loyal.
I still, you know, respect and appreciate the efforts and the people that run this company, but bottom line, you know, it didn't need to come to court, but it has.
I think the judge made an excellent call, and I think we saw justice on the incident.
Bob pulled me aside numerous times. I mean, we have this whole sexual harassment thing going on.
I don't believe that you called her for the purpose of getting her a paycheck.
Getting mixed signals.
What are you looking at me like that for? What am I saying to you that you don't understand? Why are you looking so confused? Are you confused about what I said?
is suing his former bartender, 24-year-old Brandy Bradburn, for not repaying a loan. Brandy is countersuing for her last paycheck.
Order. All rise. Judge, this is case number 605 on the calendar in the matter of Fleming versus Bradburn.
Thank you.
Parties have been sworn in. Judge, you may be seated. Folks, have seats, please.
Mr. Fleming, I've read your complaint. It indicates that the defendant was an employee of yours in your bar.
That's correct, Your Honor.
And she was there for how long?
About 10 months.
What kind of work did she do?
She was a bartender.
According to you, you made a loan to her of some money.
That's correct.
And she didn't repay that loan.
Not yet, no.
What was the money for?
Well, it was to pay off a speeding fine which had gone to a warrant. It was for minor repairs to her car, which she couldn't get insurance on. It needed smogging, and she wanted to pay the licensing for it too.
And how did the loan come about?
Well, one evening she was closing up after the day's trading, and I noticed she was crying. She was pretty upset, and I assumed that one of the customers or something had happened to upset her. When I inquired as to what was wrong, she was a bit reluctant to tell me at the start, but finally I said, look, leave the money alone, because if you're not counting it properly, she couldn't concentrate, and sit down and tell me what the problem is. Finally she did, and she said that this speeding fine had gone to a warrant. She was concerned, very worried, that she was going to be arrested, etc., etc. She had an estimate for the repairs and approximate for everything, and it came to about $650. So I said, look, I'll lend you the money. Don't worry about it anymore. Concentrate on your job. You're no good to me if you can't, if you can't concentrate. And we'll get this matter sorted out. You can pay me monthly. She said, Bob, if you lend me the money, I'll pay you weekly. I said, fine, not a problem. I paid the speeding fine the very next day. And then later, it was 2 days later or something, I gave her the money for the repairs, for the smog, for the insurance, and the licensing of the vehicle.
Did you personally pay the speeding ticket?
Yes, I did.
And how did you go about doing that?
On a credit card over the telephone.
Had she given you the ticket?
No, she gave me the details, and I called the Riverside Police Station. They had it on file, of course.
When you say she gave you the information, how did she give you the information which enabled you to call the Riverside Police?
She gave me her name, date of birth, license number of the vehicle, the date that the booking occurred.
Okay. You clearly acknowledge that he paid this ticket.
Yes, ma'am.
Let's start with the ticket. Tell me your version of the events about the ticket.
I did get the slip. I got it in the mail, and I took it to work with me that day. So it wasn't at night when I was counting my money out, and I was upset about it, but I wasn't hysterical. And I did talk to Bob about it. We were friends at one point, and I did talk to him about it, and he did tell me not to worry about it. And I had left the slip there that I'd gotten in the mail. The next day when I came in, Bob handed it to me, and he said, "I've paid this for you." I told him that I would have to pay him back, and he told me not to worry about it. And then we went through this forever about me asking to pay it back and he telling me not to worry about it.
Let's get to the other money that you borrowed from him. What'd you borrow that for?
Ma'am, I did not. Bob had given me a check one time for $1,500 that I ripped and promptly gave back to him.
Smogging your car, insurance on your car, license plates for your car. He didn't pay for any of that for you?
No, he didn't.
You have any proof, sir, that you gave her money other than paying this ticket?
Yeah, Mr. McCarthy was there when I gave it to her. It was in the morning.
Is this your partner?
Yes.
Step up, sir. Mr. McCarthy?
Yes, ma'am.
Were you present when he gave her the other $400?
Yes, ma'am.
Did he give it to her in check or cash?
Cash.
You saw her accept it in her hand?
That's correct.
Bob never, ever, ever, at any given point, ever gave me cash in my hand. Ever. And about the loan that he says it's a loan, Bob pulled me aside numerous times. I mean, we have this whole sexual harassment thing going on. I mean,
you're going to tell me about your counterclaim in a minute. Right now I'm talking about his lawsuit, which I find a couple of things suspect about your answer. Let me read you a few things from your answer.
Oh, yeah.
First of all, you just told me that this was a gift. He said to you, don't worry about paying me back, don't worry about anything else. Right. But in your answer, which is your sworn statement, you say, Bob told me that if I did his books at work, he would pay me $50 a week in cash and deduct $50 a week from the ticket he paid for me.
Right, Your Honor, but in my defense, I was after him all the time. My mother even offered to pay that money to him. I offered to pay it. Finally, he said, if it really means that much to you, you can help me out doing my books, and I'll take $50 off and pay you $50.
Good. So then there was an agreement that you would do his books and he would deduct $50 a week.
Right.
How long did you do his books?
Approximately a month and a half.
Did you do your books?
Yeah, she was helping with the paperwork. Yeah.
About how long?
Like she said, about a month and a half.
Okay, so that's 6 weeks. And did you pay her?
6 weeks.
Did you pay her for doing that, or did you actually deduct the $50 a week?
No, not to my recollection, I didn't.
So 6 weeks, $50 is
$300.
okay. So that we're clear, I believe that he gave you this other money, and including the parking ticket, you owe him $650. I'm deducting the $300 that you should have got for doing the books, because you should get credit for that. That was your agreement. That leaves $350 left. Now let's get to your counterclaim. Ms. Bradburn, say in your counterclaim that he refused to give you your last paycheck.
Correct.
Tell me about it.
Okay, the night that I left work, I'd left really upset and I'd quit and I'd walked out. 2 days later, I'd called him and asked him if I could pick up my check. He was at the bar. He told me, yeah, fine, whatever. It was a real short conversation. So I went down there that evening with Rich, who was my boyfriend at the time. I went down there that evening to pick up my check. The bartender that was working told me that my check was not there. I asked her if she would get Bob on the phone. She got Bob on the phone. I talked to him. By the time I got off the phone with him, I was in tears. He called me all sorts of things, told me I wasn't getting the money.
How much money did he owe you at that point?
Approximately $300 is the minimum I should have got for the time I'd worked.
How many days' pay was that?
A week and a half.
When she left, was there money outstanding?
She had a paycheck to pick up. Yes, there was.
How much?
I think it was, from memory, I think it was $160. That's all.
Did she pick it up?
No, she didn't. I haven't seen her since the time she left. This is the first time I've laid eyes on her. And I haven't spoken to her in the meantime. I tried on several occasions to contact her. Her telephone had been disconnected. I talked with friends of hers who said that she had moved back home with her parents into some house that they just recently rented. Nobody knew where it was. I finished up calling her grandmother on 3 occasions and left messages there.
What were you calling her for?
To find out what to do with her paycheck, where to send it to. I had no address, I had nothing.
Your Honor.
Yes.
Your Honor, that's all a crock of... If he had my grandmother's number, he obviously had my mother's number. He never once tried to call them.
Judge Judy will continue in a moment.
I, quite frankly, Mr. Fleming, don't think that somebody is in business like you are as Santa Claus.
And later today,
everybody has one life to live, unless you think you're going to come back as an Eskimo pie. Right? You have one life to live.
real cases, real people. Judge Judy. Bar owner Robert Fleming claims former bartender Brandy Bradburn owes him for a loan. Brandy says Robert owes her for her last paycheck.
Mr. Fleming, let me tell you something. You know, sometimes a little bit of truth on this side and a little bit of truth on this side, sir. I don't know of an employer who was acting reasonably that would make as many phone calls and contacts as you just told me you did to try to give her $160. Maybe my boss would do that if I moved. No, he would. But I don't know of any normal person who would do that ran a business establishment. Now, if you told me that you called her to find out whether you were going to get your money back, that I could understand.
I didn't call her for that purpose.
Why not?
I wrote it off, to be honest with you. I thought, well, that's the end of that.
You see,
I'll
my
never
problem
see
is,
my
let me
money.
tell you what doesn't make sense, Mr. Fleming. What doesn't make sense is you're prepared to write off the money that she owes you,
Right.
but you're not prepared to write off money that you owe her.
Well, that was her...
Doesn't make sense to
it
me.
was her wages.
Does that make sense to you?
Not at all.
One is, you say it's her wages.
She
On the
earned
other-
it.
shh, Mr. Fleming. Look at your partner over there. He's got it. You see, if somebody owed me money and walked out and quit in a huff over whatever reason, right, I would say, I'm going to get stiffed from the money she borrowed from me. What you're saying is you owed her at most $160. So if I were a person, I would use my math and I would say to myself, I'm still in the hole $70, right? But at least I'm going to write off her pay for what she owes me. because I, quite frankly, Mr. Fleming, don't think that somebody is in business like you are as Santa Claus.
Your Honor, can I say something?
Sure, step up. Who are you?
I'm Brandy's mother.
Go ahead.
I know for a fact that she did not borrow $400 from this man. We knew that there was a ticket. She'd gotten the notice. She'd taken it to work. She'd left it there. She came back the next day. It was paid. I went up to this gentleman.
Just a second. You don't know any of that. You don't know any of that. That's what your daughter told you.
That's what I told her.
Shh. That's what your daughter told you. What are you looking at me like that for? What am I saying to you that you don't understand? What I'm saying to you is you don't know that. You know what your daughter told me. She's already told me the story. The fact that she repeated the story to you doesn't make it true.
Your Honor.
Why are you looking so confused? Are you confused about what I said?
Well, it's very simple. I know for a fact that she didn't take the money.
How do you
I know my
that?
daughter.
Just because you know your daughter. Sit
Period.
down.
I
Sit
know my
down.
daughter.
Sit down. All right. $650 less $300, which you should have gotten for taking care of his books, leaves $350. Now, since neither one of you can tell me exactly how much your last paycheck was, because you don't have a clue, you have.
I can give you the last 3 paychecks prior to it, Your Honor.
Fine. What were they?
Strike an average, and I've also.
Good.
One was for 160. One was for 110.
Mm-hmm.
One was for 177.50.
Mm-hmm.
And the other one was 205. And part of that.
And that's a week, is that right?
Right.
That's right.
That's a week.
That's
so
$5
all of a
an
sudden,
hour.
so just a second. So all of a sudden, you made twice as much?
No. I didn't
just
say
told-
that. I didn't say that. I was just adding in the fact that he said he was going to pay me on top of that. So I just added the $50 for that week.
I'm just looking at your last 4 paychecks, madam.
Understood.
They didn't get to $300. Judgment in this case is for the plaintiff in the amount of $200. I'm averaging the last paycheck at $150. Thank you very much. That's all.
All right, excuse, you may step out.
I think he's a big liar. He always has been, and a cheat and a thief.
Don't lend money out to people. They only end up screwing you.
He's asking me to marry him and have his children and dump my boyfriend and change my life and touching me and grabbing me and keeping me and irritating me, so I left.
There's never been any harassment.
And now the next case.
All parties on Redding versus Ullman. Step forward, please.
36-year-old Carlene Redding claims her ex-husband, 41-year-old Thayer Ullman, owes her for a credit card bill. Thayer says that bill was covered in the divorce.
How long are you folks divorced?
It's been approximately 2 years.
Is that correct?
2.5.
Did you have an attorney?
Yes.
Did you have an attorney?
Yes, I did.
This lawsuit, Ms. Redding says that your former husband caused you to have a credit card bill that you think he should pay for.
Yes.
He says that that was all resolved in the divorce, right?
Yes, ma'am.
Let me see the judgment of divorce while I'm asking you some questions. See it, please.
It's on page 3 of the property. So.
Now, Ms. Redding, what credit card is this?
Citibank Visa.
When were you separated?
Probably 6 months before that.
6 months before the divorce? Is that right?
Yes.
September of '96 is the date of your divorce. On page 2, which is an important part, you directed me to page 3, but on page 2 it says the petitioner and respondent shall each indemnify the other. That means that you'll cover the other for court costs. And it further says that any other debts or obligations incurred in his name, is your name, since the separation are yours, right?
That's right.
That's what it says. So 6 months prior to your divorce would be March of '96. So show me these bills that you have from Citibank Visa that you claim he is responsible for.
This card was run up way before she even left anyway, because it was already maxed out.
I just want to see, sir, if there are any charges there after March of 1996.
Yes, ma'am.
If there weren't any charges on that card that were yours after 1996, then Miss Redding is responsible because she agreed to pay the Citibank card in the divorce.
Judge Judy continues in a moment.
You're the one who's ultimately going to suffer. You put a period to the end of this relationship, you got a divorce, move on with it.
Real cases, real people. Judge Judy. Carlene Redding is suing her ex-husband, Thayer Ullman, for a credit card bill.
So, Ms. Redding, what I want to see are those charges that were made after March of 1996. All right. This Citibank Visa card you agreed to pay for in the judgment of divorce. You were represented by an attorney.
Yes.
Fine. So this card had a substantial balance on it.
I did not run it up.
Listen to me. Man, let me take care of this business my way first. What is Klepper's Corner?
That's a gas station, Your Honor.
Do you use that?
I put probably 4 or 5 charges in the gas. We both did.
I'm talking about after March of 96.
I didn't think there was any charges after. Because
March
she
of
had
96,
left.
I have a Klepper's Corner, $19. Another Klepper's Corner, and that's gas. Is that right?
Yes, ma'am.
For $23. And another, what's Phillips?
It's a gas station, too.
It's a gas station. Well, who fills up there?
Not me. I pay cash.
Do you still live in the same area?
No, I live in Salina, Kansas.
And where do you live?
I live in Fallon, Kansas, which is a small town outside Salina.
But you live in Salina?
Yes.
When did you move there?
Shortly after our divorce.
After your divorce or after your separation?
Separation.
Well, then these are all your bills.
That's right.
Because this is all from Salina, Kansas. All of these gas cards are from Salina, Kansas. And they're not very much to begin with. Let me tell you what they are. You're talking about $100. Period. The rest of the bills are yours, madam. I mean, so what did you bring him here for? Come on, talk to me.
I can't afford to pay this.
Well, but that's not his fault. And the judgment of divorce clearly says that any bills that were incurred after the parties separated are their own individual bills. Now, you understood this, right?
To a certain extent, yeah.
Yeah, but you can't come back 2 years later and say, I just can't afford to pay it, and they want to do a do-over.
Your Honor,
What?
when we separated, she had the choice of what bill she was going to pay. For 2 years, she has done nothing but harassed me, harassed my family. My daughter has gone to a counselor for over 6 months because of this woman. I don't belong here.
Judge Judy will continue in a moment. Are you in a family dispute? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Ms. Redding.
Yes, ma'am.
This marriage is over.
Yes.
You have no children together?
No.
Good. You had a divorce. You had counsel. It's finished. And I'm just going to say to you that everybody has one life to live, unless you think you're going to come back as an Eskimo pie. Right? You have one life to live. And if you're going to spend your life on a lot of negative energy, you're the one who's ultimately going to suffer. You put a period to the end of this relationship, you got a divorce, move on with it. These are your responsibilities. You have to take care of them. You got to leave him alone, because if you don't have children together, there is absolutely no reason for you to have any contact with this man or his family. And if you do, one of these days, he's going to file a lawsuit with you civilly for harassment, or he's going to have you arrested criminally for harassment. Do you understand?
Yes, ma'am.
That's going to be very unpleasant. This case is dismissed.
Parties are excused. You may step out.
Judge Judy will continue in a moment. And on the next Judge Judy.
Your lawsuit claims that the defendant assaulted you by spitting at you.
A spit and a spat.
You know, when you get face to face with somebody, I mean, little spray got on her.
Judge Judy Justice.
I wasn't the one to run the credit card up, and I haven't been harassing him like he says I have.
I want her to leave me alone, leave my family alone. She's affected all of us. It's over with. She knows she needs to take responsibility for her bills. It's over.
He just insulted me on national TV, that's all.
दूर गया सावल दूर जुदाइयां वे पै गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने अरमान ही रह गया है अरमान ही रह गया है सज्जन वे दूर होया रोना उम्र दा पै गया है टूर गया सावल दूर जुदाइयां वे पै गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने गला करा तन्हाइयां नाल गला करा तन्हाइयां नाल मौत नी कुछ कहंदी मर जा जुदाइयां नाल टूर गया सावल दूर जुदाइयां वे पै गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने होसी दीद कद प्यारां दा होसी दीद कद प्यारां दा दिल वे दुखा गया है दुख विछड़िया यारां दा टूर गया सावल दूर जुदाइयां वे पै गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने ना दिल तरसा ढोला ना दिल तरसा ढोला छोड़ मजबूरियां नू बेला वक्त न ते आ डोला टूर गया सावल दूर जुदाइयां वे पै गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने दिल विच बस अरमान ते यादां ही रह गईयां ने टुटी बारी साडे बंगले दी टुटी बारी राजी रखे रब डोला बंदा मिलदा ते लख वारी राजी रखे रब डोला बंदा मिलदा ते लख वारी सोनिया असी दुखां विच जी लांगे तू सुखी वस सोनिया असी दुखां विच जी लांगे कोई सिगरेट राई देवे कोई सिगरेट राई देवे गैरां ने केस कीता मेरा सज्जन गवाई देवे गैरां ने केस कीता मेरा सज्जन गवाई देवे कोई कापी रद्द कीती कोई कापी रद्द कीती एक ते गरीबी है तुझे सजना भी हद कीती एक ते गरीबी है तू सजना भी हद कीती गड्डी पुण छनु जांदी है गड्डी पुण छनु जांदी है लोकां दे माई वेखां सानू याद तेरी आंदी है लोकां दे माई वेखां सानू याद तेरी आंदी है अकबाल के सेकण दे अकबाल के सेकण दे रब तेनू हुसन दिता सानू रज रज वेखण दे रब तेनू हुसन दिता सानू रज रज वेखण दे कोई उड़दा जहाज़ों सी कोई उड़दा जहाज़ों सी असां कदे सोचिया नहीं ढोला तो के बाज़ों सी असां कदे सोचिया नहीं ढोला तो के बाज़ों सी यारी होवे मतलब दी लानत एहो जी यारी ते यारी होवे मतलब दी लानत एहो जी